make an appointment. And the conclusions are what they are, what this court has said. Entirely different inquiry to whether or not the constitutional requirements for the exercise of a power are present and whether they have been exercised rationally.
I'm sorry, Mr. Semenya, in both matters, is it not correct that the power to be exercised by the president was sourced directly from the Constitution, both in Albert and the Simelane matter?
Correct.
Is it not correct also in Albert that this court expressly said it would not determine whether that exercise amounted to administrative action or something else? It would not even determine whether PAJA applies or not.
Correct.
But it proceeded on the assumption that it was constitutional power coming from the Constitution, but because without that consultation, the president would not have achieved the objective of reconciliation and nation building. And therefore, the court said the procedure adopted by the president was not rationally connected to the attainment of the purpose for which the power was exercised. Or am I wrong?
No, you indeed right, Justice Jafta. The point perhaps is one of language. I am not denying that in all these instances, there was an exercise of a power residing in the Constitution. That I accept to be correct. All I think I was trying to convey is the fact that the interpretation issues relating to the exercise of a power and whether or not that exercise has been done rationally, it's the point I'm making. That where, even if it were rational, but a constitutional provision required consultation, you are not going to jump the hurdle. We'll find out, yes, your decision is rational, yes, it may meet the purpose, but if the Constitution additionally requires you to do it after consultation, then I'm saying you can't survive on rationality absent the consultation. I don't know whether I'm lucid enough in relation to my response, but
I'm not going to detain you any further, Mr. Semenya, on this point. The point that I wanted to make is that I understand your submission insofar as, sorry, the ordinary procedural fairness is concerned.
Okay.
Matters where it is a legality review, the procedural fairness would not apply. And sorry, in that context, you are in the company of decisions like Masitla.
Yes.
You don't have it there. But this is slightly nuanced. If consultation must be part of the procedure leading up to the decision, which makes the means to achieve the end in terms of rationality, if that procedure requires consultation, then consultation must be undertaken. So that's the only point that I was making, which is slightly nuanced. I'm not querying your argument insofar as procedural fairness is concerned. I think that is settled by Masitla. You can't raise it in a legality review, but you can raise it in a legality review as a procedural rationality point.
Indeed, I'm making no higher point, Justice Jafta. Can I emphasize the point?
Yes.
That when you look at a provision in the Constitution which requires a procedural element, it uses the word after consultation. That is a procedural requirement before you can exercise that power. And I'm saying if consultation in 139(1)(c) was to be exercised after consultation, the Constitution would have done so. It didn't. But the same document, when it requires that procedural requirement to be present, it does say you can exercise this power after consultation with so-and-so, or you can exercise this power in consultation with so-and-so. I raise it no higher than that.
But that submission seems not to find support in Albert, because if you look at section 84(2)(j) of the Constitution, which was involved in Albert, which deals with the pardoning of prisoners, it does not expressly say you must consult family members of the victim before you can grant pardon. It's not in the Constitution. But in Albert, this court says, once you accept that your end, your purpose is to achieve nation building and reconciliation, if you adopt a procedure which leaves out the victim members of the victim's family, that in itself makes it impossible for you to achieve the reconciliation, which is your purpose. And therefore they said that raises a misalignment between the procedure full adopted and the purpose to be achieved. So that's where the issue of procedural rationality comes in.
No, I think I have a much better way of giving an answer to the question, Justice Jafta.
Okay.
In relation to that, the court was really saying you can never reach a rational connection without hearing those victims. It was not saying anything else. And I can understand why it goes the way it does, because it says, if you're not taking this information, how on earth are you going to make a rational decision? Yeah. So it is interrogating the rationality between the power and the purpose for which it is intended. It is not saying, as an inquiry about legality, you have a duty to hear somebody else. Now I think I understood what the question is, and that is my submission that I'm making.
Okay. Thank you, Mr. Smith.
Chief Justice, the other points are really here and everywhere. Can I deal with them if they arise out of, in my reply, if they merit a response?
You seem to have forgotten my question, Mr. Sumaya.
Oh, yes, sorry. Whether there is, Justice Majid, whether or not there is a jurisdictional fact in A and B and C, or what are the jurisdictional facts?
Yes, correct.
The answer in my submission is that when you go to 139, the very first jurisdictional fact you must establish is whether or not the municipality cannot or does not fulfill a particular executive obligation, which is in terms of legislation of the Constitution. That seems to me to be the inquiry. The relevant obligations, the relevant provincial executive may then intervene by taking an appropriate step. Any appropriate step, it seems to me, is the other jurisdictional power that it can have. There is the intervention, the power of intervening. And it says you have a whole number of appropriate steps that you can take in the fulfillment of that obligation, which the municipality cannot or does not fulfill. And then it says to me, I'm going to give you examples. Such steps may include A, the directive element, B, you assuming the responsibility, And then it says, in your intervention, you can also dissolve the municipality when certain factors are present, where that dissolution is warranted by the exceptional nature of the failure. That is the opening paragraph of 139. That would be my response, Justice Majid.
Yes, as I see the section, the provincial government can take a number of steps, not only those listed there, obviously. It could also, for example, in the spirit of cooperative governance, call for a meeting without assuming responsibilities or issuing directives. And the question then would be, as far as appropriate steps is concerned, is that suitable for the circumstances and the exigencies of the situation then prevailing? And so also with the directives and with the assumption of responsibility. That is a standard jurisdictional fact. But a higher jurisdictional fact is required when you get to 1391C. Is it A, appropriate, stroke suitable, but B, also do the exceptional circumstances warrant that step? It seems to me to be an extra jurisdictional fact which must be proved over and above the fact that it is suitable for it is a suitable step. That's how I see it.
No doubt, I see it as well like that, Justice Majid. And that's why we say, if you go over the additional measure and you show that exceptional circumstances, then you can do the dissolution and take the matter to the voters.
Yes, thank you, Chief Justice.
Thank you, my brother. Yes, thank you, Mr. Semenya. Is there still something you want to say based on what you said earlier?
No, the Americans would say, I yield.
Thank you very much. Thank you, Mr. Semenya.
Excuse me, Chief Justice. Mr. Semenya, yes. You had the mandamus to discuss.
He says he will deal with it if it does arise in the course of Mr. Bartlender's argument.
Okay.
I understood him to be saying it's in my papers, and if nobody makes much of it, I'll assume that my papers speak for themselves.
Yes, Chief Justice.
Thank you very much. Mr. Bartlender?
Thank you, Chief Justice, members of the court. Chief Justice, we have listened very carefully to the debate between the bench and our learned friends. And we, of course, will not repeat what is in our heads, although we stand by everything set out there. We propose in the course of this address to deal with 6 issues. The first is what and who is before the court, because it's necessary to deal with this argument that the procedural fairness point is somehow beyond the court, which we're going to submit to the court is just on well-established authorities, quite wrong. And then also the role of the EFF. So that's issue 1. We will then turn to deal with the standard under section 139(1)(c), and we will do so mindful of the concessions that our learned friend for the government has made, but we of course will address the points that our learned friend for the EFF has diverged from him in that regard. Thirdly, we will deal with the failure of the provincial government to consider any options besides dissolution in taking the dissolution decision. And allied to that, we will deal with the failure of the provincial government even to consider the responses that were given to it in response to the earlier notices. Fourthly, we will deal with the failure of the provincial government to engage in any form of consultation on the question of dissolution per se, and demonstrate that that by itself is fatal to the decision. Fifthly, we will deal with the question of the mandamus. And sixthly, we will deal with what this court should do in light of the fact that almost double the 90-day period has passed since envisaged in the Constitution. And that arises out of your question, Chief Justice, to the Gauteng, to our learned friend, Mr. Nkatobi. Chief Justice, if I may then begin with the first issue, and may I say, Chief Justice, in view of the way the debate has moved on, and in order to save time, we waive our protected time. And so if there are questions that arise, I would be happy to deal with them as they arise.
Thank you.
Thank you. Chief Justice, there is a debate now arising from the submissions of our learned friend for the government as to whether the procedural fairness question, as he calls it, or the procedural irrationality question, as I would call it, and as it was pleaded, whether that is before this court at all. Our learned friend says that the High Court didn't reach that question and didn't decide it, and that is correct. The High Court declined to do so because it found that it was unnecessary for its decision. But with respect, our learned friend is quite wrong when he makes the submission that that means it's beyond this court's competence to reach the point, absent a cross appeal. And I must say, Chief Justice, with great respect to my learned friend, who is a friend of mine, it is the most surprising submission I've ever heard him make. And the reason it's surprising is exactly the reason that Justice Madlanga already offered. One only needs to appeal, or more accurately, cross appeal, when one seeks a variation of the order granted by the lower court, not its reasons. So, I'll take you to the authorities now. And that is because an appeal lies against an order, not the reasons. And I'm going to demonstrate to you on very well-established authorities that not only was a cross appeal not necessary, it wasn't even permissible by my clients. And that is the point that Justice Madlanga highlighted in the debate. Could I begin with the authority? It's an old authority, but it's been repeatedly cited. It's the decision in Western Johannesburg Rent Board versus Ursula Mansons, 1948, volume 3 of the South African Law Reports, at page 353, a decision of the Appellate Division at 355. There, the Appellate Division held, and I quote, "It is open to a respondent on appeal to contend that the order appealed against should be supported on grounds which were rejected by the trial judge. He cannot note a cross appeal unless he desires a variation of the order." So it's absolutely clear that if you rely on 3 grounds and the High Court upholds 1 and rejects 2 or doesn't decide 2, you are entitled to defend the High Court's order on the basis of grounds 2 and 3. Western Johannesburg Rent Board makes it absolutely clear. It is made clear again by the SCA in SA Reserve Bank versus Kumalo, 2010, volume 5 of the South African Law Reports, page 449, the decision of the SCA at paragraph 4, where the SCA held an appeal lies against an order that is made by a court and not against its reasons for making the order. It follows that on appeal, a respondent is entitled to support the order on any relevant ground and is not confined to supporting it only for the reasons given by the court below. And I should say that the decision in Western Johannesburg Rent Board has been cited in this court with approval by Justice Jafta in his dissent in the Mass Stores case. That's Mass Stores versus Pick and Pay, 2017, volume 1 of the South African Law Reports, page 613, a decision of this court at paragraph 59. Justice Jafta was in dissent there, but not on this point. And Justice Jafta said, the appeal can succeed if it is shown that the order was issued, if the order issued was not supported by the facts on record and the application of the relevant law to them. A decision of a court is not overturned merely because the wrong reasons were invoked to support it. In our law, no appeal lies against reasons in a judgment. Instead, the appeal lies against an order. Hence, it often happens, says Justice Jafta, that an appeal is dismissed, but for reasons different from those advanced by the lower court, whose judgment is the subject of the appeal. Now let me be absolutely clear. We submit that the High Court's reasons were absolutely correct, and the court need not reach the procedural point. But if the court wishes to reach it, and if the court were to find that the High Court was wrong in the reasons it gave, then the court would be required to reach it because the point appears from the papers and is argued. The only point that remains is the suggestion by our learned friend that if this court were to decide the procedural question, it would suffer an injustice. The provincial government would suffer an injustice. But that, with respect, is plainly wrong. Because what our learned friend does is he seeks to rely on what is said in the answering affidavit in opposition to his client's application for leave to appeal. But he didn't actually take you there. Could I take you there? It is to be found, the relevant passage is to be found in volume 9, page 876, paragraph 15.2. And what the court will see there is that my client says at 15, the applications for leave to appeal are starkly inaccurate when they deal with the grounds of the full court judgment. Firstly, there's a debate about rewriting the test of rationality. And then secondly, 15.2, moreover, the Gauteng government addresses vast swathes of its affidavit to the issue of procedural fairness / rationality. But the full court's judgment was not based on procedural fairness at all. It expressly declined to decide the issue. Well, that's correct, of course. The full court didn't decide it, and it decided it didn't need to. And so our complaint was, why do you make a long speech about procedural fairness in an effort to show that you've got reasonable prospects of success? Because the full court didn't rely on procedural fairness. Could you please deal with the grounds the full court did rely on? So this is not an abandonment of the point. It's not an somehow acceptance of anything. It is simply a recording quite correctly that the full court didn't decide the issue. And so when you ask the question, Chief Justice, in answer to my learned friend's submission, was there injustice? Was there unfairness? Well, of course not, because the facts are squarely on the papers before the court. The court will see that this issue is pleaded right up front in the founding affidavit. I'll give you a reference, but the court need not go there. It's volume 1, pages 31 to 33, paragraphs 88 to 94. So it's on the facts. It's been answered on the facts, squarely. And of course, it's in our heads at paragraphs 85 to 107. And the mere fact that our learned friends decided, for whatever reason, not to address the point in their heads doesn't give rise to an injustice and could never preclude the court from dealing with it. So we say that all of the grounds relied on by my client are before the court, including that ground. The second question is who is before the court? And we merely wish, in light of the question posed, I think by Justice Chiki, to draw attention to a relevant authority on that court, because Justice Chiki put it to our learned friend, Mr. Semenya, that she was surprised to see the EFF here, given that they'd abided in the court below. And of course, that too is a point that we raised in our answering affidavit in this court. We would simply commend to the court the decision of the SCA in Cilliers versus Ellis. It's Cilliers versus Ellis, 2017, ZASCA 13, 17 March 2017, at paragraphs 22 to 23.
Mr. Bartlender, 2017, what is the volume?
It's a neutral citation. It doesn't appear to be reported, I'm afraid. It's 20.
I thought it was an error.
No.
And the page, you said the page is?
The neutral citation is 2017, ZA 13.
Is that the paragraph number?
22 to 23.
Okay.
And what that judgment does is it re-endorses the old principle laid down by the AD, that if you abide in a court below, you are perempted and prevented from appealing to a higher court. Now, we leave in the hands of this court what it should do in that regard. And I must apologize both to the court and my learned friends for not having drawn attention to this judgment before. I discovered it literally at 10 to 10 this morning, and that is the reason that it is referred to for the first time in argument.
Bartlender, I'm sorry, Mr. Bartlender.
Yes.
I seem to think that there is a judgment of this court on a matter where someone who was not even a participant in the High Court,
yes,
sought to appeal to this court,
yes,
because the order affected their interests.
yes.
And this court permitted them to appeal.
Yes. Justice Jafta, I accept that the test is the interests of justice and that this court will apply that. And I also accept that this court has allowed non-participants to appeal to it. It may be that the case you had in mind was Saidumo, where COSATU was entitled to appeal, even though it was not a party before the SCA.
Yes.
and that's why I leave the point in the court's hands as to the interests of justice.
Okay.
But I raise it because Justice Chiki raised the question, and the authority appears to us to be the relevant authority. Could I then turn to the second point of the 6 we mentioned, and that is the standard under section 139 of the Constitution. And we deal with that standard, as the court knows, in paragraphs 24 to 41 of our heads of argument. And we commend those to the court because it seems to us with respect that the authorities we cite and the logic there is correct. So it's paragraphs 24 to 41 of the heads. And we make the point that a fundamental starting point in understanding section 139 is that local government is no longer a subordinate sphere of government. It is an independent sphere of government. Our learned friends say interdependent, but it is also independent. The idea is that there are 3 tiers of government and they each have their own powers sourced directly from the Constitution. And that is the reason that this court has held that the powers of intervention must be tightly constrained and applied. Now, in the province's heads, the contention was, and it is really the thrust of the heads from start to finish, was that a mere rationality standard applied. Again and again and again, our learned friends for the government told us it was a mere rationality standard. And that is the only basis, I point out, on which they have sought to defend the substance of this decision in their heads. But there has now been a substantial shift by our learned friends, and it is a shift which we submit is correct. And the shift is a shift away from mere rationality, because our learned friend, Mr. Ngulkatobi, expressly concedes now that the test is higher than mere rationality. It must, in his words, fit the situation. In his words, it must be designed to fix the problem. In his words, it must be appropriate to fix the problem at hand. In his words, the court can set it aside, the dissolution that is, if it is not appropriate on the facts. And in his words, it must be reasonably capable of fixing the problem. Now, we welcome those concessions because it seems to us that they are properly made. I'll come to my learned friend's submissions in a moment, my learned friend, Mr. Semenya's submissions, but we submit that they are properly made. But we submit with respect that his attempt then to say, all of that is true, but any element of proportionality or less restrictive means doesn't enter the picture, we submit is untenable. Because once you concede, as you must, that the dissolution has to be appropriate, which this court explains has meant fitting, suitable, proper, and effective, that's the EFF judgment. How could it ever be fitting, suitable, proper, or effective to use, in the old analogy, a sledgehammer to crack the nut? How could it ever be appropriate, fitting, suitable, proper, or effective to use a sledgehammer to crack the nut? Now, whether you call that less restrictive means, whether you call that an element of proportionality, whether you call that justification, there is plainly an element of proportionality in there. But it's even more clear when you read the word appropriate in context with respect, because when you read section 139, what it says is, where a municipality cannot or does not fulfill an executive obligation, the relevant provincial authority may intervene by taking any appropriate steps to ensure fulfillment of that obligation. So it's not just appropriate steps. It's not just fitting, suitable, proper, or effective steps. It's fitting, suitable, proper, or effective steps to ensure fulfillment of the obligation. And if you use a sledgehammer to crack a nut and you do more than is necessary, then you are not adhering to the jurisdictional requirements of 139.1, Justice Majid. But now that's the jurisdictional requirement of 139.1, that appropriateness, and it applies to A, B, and C. In C, there is the additional requirement, because C says there must be exceptional circumstances. But it doesn't just say exceptional circumstances. It says you can do this, and I'm quoting now, if exceptional circumstances warrant such a step. Now, while our learned friends spent a great deal of time on the word appropriate, neither of them dealt with the word warrant. We have given you in our heads the dictionary definition of the word warrant. It means to justify or necessitate. So what does the section say? It says that you can dissolve a municipal council if exceptional circumstances justify or necessitate such a step. So what that makes clear with respect, again, is an element of proportionality. You cannot use the sledgehammer to crack the nut. We don't say that relying on 36(1)(e) or the limitations analysis. We say we rely on the language of 139(1) and 139(1)(c). And indeed, our learned friend was constrained to concede, as we understood it, in response to Justice Theron's question, that there was an obligation on the Executive Council to consider all three 139 options. Justice Theron posed that question to him and he appeared to accept it. And that must be right, because how on earth can you decide what is appropriate or what is warranted or what is fitting, necessary, effective without considering the options available to you? And so when our learned friend appeared to concede that you had to consider all three options, he was right. And with respect, he then went on to say that they did consider all three options. But I'm going to demonstrate to you that on these papers, that argument is wrong on the facts. But as a matter of law, we submit that when you are dissolving another sphere of government, and let's just call a spade, you have one sphere of government dissolving another sphere of government's elected officials and putting paid to the views of the voters. Now, sometimes that will be necessary, but it is an extraordinary step. And to suggest that you don't have to consider less restrictive means in that context, or put differently, to suggest that you don't have to consider whether a 139(1)(a) or 139(1)(b) would work, we submit would plainly be inconsistent with the constitutional scheme. It would plainly be inconsistent with 139. It would be inconsistent with section 41, as a number of judges have put, and we say it would be inconsistent with what this court held in the second certification judgment, that when you look, and we've quoted that in the heads, when you look at what 139 says, you must also have regard to 41. So we submit with respect that the attempt to say mere rationality is plainly wrong. The acceptance that there's a shift from that is a correct concession, but the attempt to say proportionality or looking at other means is irrelevant, we submit is quite wrong. Our learned friend, Mr. Semenya, then, however, didn't appear to...
Mr. Butland, I'm sorry, before you move on, I just need clarity on this one. I understand your submission in relation to the qualification to the exceptional circumstances requirement.
Yes.
That they must be of a particular nature.
Yes.
That warrants the step taken. Should we read that as a guide to the proportionality test that you're postulating? In other words, can exceptional circumstances warrant a dissolution and still that dissolution be inappropriate because the Executive Council, the Provincial Executive Council, did not consider A or B?
It seems to me, thank you, Justice Jafta, it seems to me that those are two different questions. The first question, do the exceptional circumstances warrant the dissolution, is a substantive jurisdictional requirement. If the exceptional circumstances didn't warrant it, then it is invalid objectively, irrespective of what they did, said, or thought. The question of what they considered is part of the process in determining whether these requirements were satisfied. And we submit that they had to consider that to get there. Now, I appreciate, Justice Jafta, that in most cases, those two things will run together. But we submit that the decision maker, could I give an example? It's like a decision maker who is asked to consider A, B, and C, but fails to consider C at all. Then the courts say, well, you didn't even consider the relevant considerations, and therefore the decision is set aside on that basis. That's the duty to consider it. But it goes further, because having considered it, you must satisfy the objective test, and our learned friend appears to accept that the circumstances warranted it. So it's both about the reasoning process and the objective facts of the case.
I am slightly confused. If the exceptional circumstances that warrant a step is to be considered as a jurisdictional fact.
Yes.
Which must exist before the power is exercised.
Yeah.
It seems to me to be like putting the cart before the horse, because now you have to determine that although there are exceptional circumstances in existence, are they of the nature that warrant dissolution, even before you exercise the power to dissolve?
You have to, in our submission, Justice Jafta, what you have to do is you have to consider firstly, whether there are exceptional circumstances present.
Yeah.
And secondly, whether those exceptional circumstances warrant dissolution. In determining whether those exceptional circumstances warrant dissolution, you will have to have regard to the other options available to you to address those exceptional circumstances. So there might be a case. Could I give an example of a case?
Yeah.
So, suppose literally there was no water available to anybody in the city of Tshwane. Something had happened with the water supply and there was no water available to anyone in the city of Tshwane. People were literally on the verge of dying from drought. I would accept that that may well amount to exceptional circumstances, but that wouldn't necessarily warrant the dissolution of the council, because you could instead, under 139(1)(b), simply assume control of the water provisioning and you would have a less restrictive means available. So I accept that there is a link, but the mere fact that there is exceptional circumstances doesn't mean that dissolution is warranted. That's the point I'm trying to articulate.
Okay, no, I understand that. I understand that, and I think it helps me, because then I have to say, as a jurisdictional fact, you have to look at whether exceptional circumstances exist or not. And that's not the end of the inquiry. Once you find that they do exist, now you have met the condition to exercise the power. In exercising the power, you have this obligation that arises from the same provision that says they must be of the nature that warrant the step that you are going to take. And I understand your argument to be saying that that is the source of the proportionality analysis, for you to get to the conclusion that these are exceptional circumstances that warrant dissolution. You have to look at all relevant facts, including A and B.
Yes.
Is that the argument?
Yes.
Okay, thank you.
Thank you, Justice Jafta. Justice Jafta, I've now, in answering your question, in fact, addressed the argument of our learned friend, Mr. Semenya, because our learned friend, Mr. Semenya, argues that once you have established exceptional circumstances, that is the end of the inquiry. But I've already explained in answer to your question why that must be wrong, because there is no provision, there is no account given by our learned friend's argument for the use of the word warrant. And I've addressed that, and I don't need to take it further. We would simply commend to the court the decision we refer to in our heads, which is on a different part of 139, but which is helpful. It's the Overberg case. It's the Premier of the Western Cape versus Overberg District Municipality. It is in our heads at paragraph 17 to 19. I want to express caution. It is about 139.4, not 139.1, and it is about a pre-amendment version of 139. But the logic that is applied there, even to a section which said that in certain circumstances, the provincial government must dissolve, we submit that that logic is in understanding the inquiry that should take place. So what we submit, Chief Justice, is it's obviously more than mere rationality. There is an element of proportionality for the reasons I've articulated, and the element of proportionality requires at least the consideration, the proper consideration of alternative means to achieve it, and that all emerges from the language of 139, but it also emerges from the purpose and context of 139, particularly when you read it in the constitutional scheme and in light of section 41. Could I now turn to deal with why the provincial government didn't comply with that provision? And that's—
sorry, just last point, Mr. Budlander. It worries me a bit. I think it may be a question of semantics, I think, between you and Mr. Ngubetobi, whether you characterize procedural irrationality as procedural fairness.
Yes.
But it seems to me it will create confusion in our law if we are to consider procedural irrationality as equating to procedural fairness.
Yes.
It might not sit well with our jurisprudence, especially in Masitla. So I think we should guard against creating confusion where it is not necessary.
My learned friend and I were remarking that when we drafted these papers, Justice Jafta, at some point the draft said only procedural fairness, and I said it's not only procedural fairness, it's actually procedural rationality, and there is a difference between the two, and we must adhere to them. And although both are used in the papers, you'll see that we are always careful to say procedural rationality, because that is the Albert standard, and that is the DA standard. And with respect, this court has made clear that the two are different. Sometimes they are the same, but sometimes they are different depending on the circumstances. And I accept, and I'll come to that in the fifth topic, but I accept that the procedural standard is procedural rationality, and not procedural fairness, because that is a Paja standard, and that's an inapposite label. In the present case, I submit it makes no difference to the outcome, but I accept that the label is procedural rationality.
Mr. Butlander, sorry, when you just on that, when you get to your item 5, when you discuss this, the matter that Justice Jafta raised with you, would you also clarify for me how you understand the remarks of the Chief Justice in Law Society of South Africa versus President of the Republic, especially at paragraphs 60, 62 and further?
Yes.
It's part of the debate with Masetla, Albert, Simelani, and then Law Society of South Africa. Thank you.
Yeah, I certainly will. Thank you, Justice Jafta. Thank you, Justice Majid. I apologize. So could I then deal with the third topic? And the third topic is the failure to consider the options other than dissolution. Now, my learned friend for the government, again, I say, appeared to accept that there was a duty to consider these options. And he suggests that his client did. And the question that the court raised with him again and again is, well, where on the papers do we see this? The Chief Justice raised it, Justice Mplantla raised it, I think Justice Taron raised it, a number of members asked the question. And the answer is that you don't see it. You don't see it on the papers. And I'm going to take the court through the papers to demonstrate that, because it is a fundamental question. And if the court would just allow me to do so, I'll do so as expeditiously as I can. Could I ask the court to begin in volume 1, page 35? Volume 1, page 35, paragraph 98.2. You will see there, this is the founding affidavit, that what is pleaded is, I'm advised that the section also includes 2 additional substantive requirements. And the second one is that the provincial government must use the least intrusive means necessary to ensure the fulfillment of the obligation concerned. For the reasons set out below, the dissolution decision does not comply with any of these requirements. And then the court will recall that when we deal with the 9, my client deals with the 9 observations, on a number of occasions that we say, well, obviously this wasn't the least intrusive means, you could have done this, you could have done that, but this is where the case on that starts. The answer to that passage is to be found in volume 4, page 362. And the court will see there, 362, paragraph 17.2, where what is stated is that to the extent that the court must consider less restrictive means, which I deny is the standard, I submit that these were applied, and it considered that they are inadequate to address the real problem on the ground. The facts set out in the DA's own application do not make out a case for less restrictive means. Now that's a bold claim, and a bald one, but it never gets shown. And so as the 9 observations are gone through, the answering affidavit never explains why other options were considered and rejected. It never explains why 139(1)(b) wasn't used. It simply doesn't even begin to deal with the point. And we deal with this at paragraphs 43 to 47 of our heads of argument. And we commend that to the court where we set out the relevant facts. But I'd like to give the court one example which deals with the point rather neatly and which is helpful for understanding the flaws in the dissolution decision. And that is the Hammanskraal water debate. Because understandably, with water being such an emotive issue, and with it being clear that there is a real water problem in Hammanskraal, our learned friends, since the outset of this case, have always emphasized the Hammanskraal water crisis. And that is always the point they raise, understandably. But I wish to demonstrate what the papers actually say about that so that we can see the true facts rather than with respect to some of the rhetoric. Could I ask the court to go to volume 1, page 43 of the papers? And could I give the court a teaser as to what I'm going to say? As I work through these paragraphs, let me tell you that the answer to all of this is going to be a bald denial. And I will take the court there in a moment. So page 43, paragraph 134, the point is made that the Gauteng Executive Committee alleges that the municipality faces a water crisis and the residents of Hammanskraal have been without water for too long. And then comes the critical allegation. This was addressed in the December response and the February response. It appears that the Gauteng EC gave no consideration to either response. So it says there's a water problem. It was addressed in our 2 responses. It appears that you gave no consideration to either. I'm going to come back to this point in a minute, but for the moment, if the court could mark that passage because it's critical. And then it says at 136, it is true that the municipality faces challenges in supplying clean drinking water to Hammanskraal. It explains where the areas are supplied from. That's the Temba water treatment plant. It explains the reason for the pollution because the Rooiwal wastewater treatment works is overloaded and unable to treat influent and are therefore unable to remove pollution. It makes the point that the municipality has continued to face challenges because it had to cancel a contract because of the incompetence of the contractor. It makes the point at 138 that the municipality is severely hampered in its attempts to address these issues by the repeated failure of the ANC and EFF members to attend meetings. You'll recall now that there's a bald denial to all of this. Over the page, 138.4, the ANC members collapsed the February 2020 meeting, blaming it on the speaker. 138.5, it is accordingly clear that the ANC and EFF councillors acted deliberately to create dysfunction and hamper service delivery in the municipality. Bald denial, it will be recalled. 139, it should be noted that the need to upgrade the Rooiwal plant before 2019 was recognized in 2004, and successive administrations have failed to address it, so it's not a new problem. And then it starts to explain the solution. There's a project to address it, that's 141, funded by the development of, they're seeking funding from the Development Bank. A portion of Temba in the meantime is being supplied from the Soshanguve pipeline. The remaining is being supplied from Temba. Over the page, the municipality has signed a memorandum of understanding with Ekhululeni Water, and the priority is the 3 critical areas, and the memoranda are attached. A special mayoral committee was established to deal with it. This report highlights and provides feedback. The report is attached to FA 37. Importantly, the report concludes that the combined activities, this is 147, the combined activities at Rooiwal and Temba will provide safe drinking water that meets the required standards in Hammanskraal. Will provide, that's the report. And then there's a quotation, and the quotation refers to the SANS standard, and there's a speaking about accelerating. And then at 148, in light of the above, the municipality has not failed to comply with its obligation to supply clean water. It is clear that the city is taking the crisis seriously and has undertaken a range of interventions designed to correct the problem. This certainly does not amount to a failure to fulfill executive obligations, still less an exceptional circumstance which justifies the dissolution of the municipality. Bald denial, you will recall. And then at 149, what is more, if the challenges faced in supplying water justify a Section 139 intervention, the Gauteng EC is required to use the least intrusive means to fulfill the obligation. In this regard, it would be far more appropriate for the Gauteng provincial government to assume responsibility for this obligation under 139(1)(b) than to dissolve the municipality. Now, the answer that is to all of that is to be found at page 433 of the papers. That is volume 5. And when you go there, 433, volume 5, the answer to all of those paragraphs I've just read, 134 to 139, at paragraph 192, save to note that the DA does not deny any of the allegations contained in the dissolution notice. I deny the averments under these paragraphs and refer to what is stated above. Well, Justices, you can look above, but
Mr.
you will.
Mr. Butlander, can I just ask clarification just on that point? I see the point you're making about the Hammanskraal issue, and I saw in the papers that the city was at pains to explain in their report what they've done to rectify that issue.
Yes.
But what bothered me and what I could not see as being able to be resolved in terms of section 139B,
Yes.
was the failure or the collapsing of the meetings. And the fact that there was no mayor, no municipal manager, and no speaker. And I kept on asking myself,
yes,
assuming the other areas like the service delivery measures could be attained by invoking section 139(1)B.
yes.
But these others regarding the absence of the mayor and the speaker and the meeting simply collapsing, how could those be resolved other
Yes.
than through these drastic measures?
Thank you, Justice Chiki. I'm indebted for the question. Could I address it immediately? Could I just finish this point for one moment? The only point we make on Hammanskraal is it's clear it is doubtful at all that this is a failure to fulfill an executive obligation. But if it is a failure to fulfill an executive, because there are measures being taken, and the executive obligation is the measure to take reasonable measures to achieve water. That's section 27(2) of the Constitution. So we say it doesn't even meet that standard. But even if it did, and even if it was exceptional circumstances, there's no showing that it couldn't have been achieved by a 139(1)B taking over of the functions. And there is no explanation at all as to why that's so. And just to finish the point, and then Justice Chiki, I will come to you immediately. It's that when the paragraph says, I refer to what is stated above, we can't find any detailed discussion of Hammanskraal in the answering affidavit. This appears to be it. Justice Chiki, the question that you raised with me with respect is a very important one, and it is one that we've considered. And it seems to us with respect that there are two answers. The first is, let me just assume for a minute that you were to conclude that there was no other way of resolving the problem with electing a mayor, etc. That on its own might, but there were many other ways of achieving water and all of the other things. That might well by itself imperil the lawfulness of this decision, because you are not told that the mere fact of the failure to elect the mayor by itself, or the mayoral committee or anything of that sort by itself was sufficient to give rise to this problem. You have a decision which has all these reasons filtered into it, and if a large number of them, or even some of them are bad, that might be enough. But let me deal squarely with your question, because we submit there was an obvious alternative remedy. And the obvious alternative remedy was the one which is provided in the Systems Act. And that is in item 14.4 of Schedule 1 to the Systems Act. Because it must be recalled that what was happening here was that the reason that these meetings were collapsing is that the EFF and ANC councillors were walking out in protest. And what that meant is that the meetings were no longer quorate. And now, could I say, one needs to draw quite a careful distinction here between a quorate meeting and the required majority, because otherwise one gets confused quite quickly. If there is no quorum, if there are not 50% present, then the council meeting can do nothing at all. They are literally incapable of functioning. And because the councillors who walked out or didn't attend were more than 50%, that meant that the meetings were not quorate. They couldn't do anything. But once you get to quorate, then you don't need a majority to pass everything. There's some suggestion, well, people would have abstained or they would have done this. For most issues before the council, you don't need a majority of the councillors. You only need a majority of the votes cast. So if people abstain, then it doesn't matter. You can still pass it. Could I just direct you in this regard to section 30.3.0 of the Municipal Structures Act? So I was first referring to the Systems Act. That's the schedule. I'm now referring to the Structures Act. And what you will see there is that section 30 sub 2 of the Structures Act says that 1, a majority of councillors must be present before a vote could be taken on any matter. That was the problem. There were not a majority, people would arrive and leave, and therefore there would not be a majority of councillors present before a vote could be taken. And 30 sub 2, all questions concerning matters in 160 sub 2 of the Constitution are determined by a decision taken by a municipal council with a supporting vote of a majority of the councillors. If you want to pass a bylaw, or if you want to establish a budget, you need 50 plus 1% of the councillors to vote in support. There's a heightened majority. But under 30 sub 4, if on any other question, but in everything else, you don't need that heightened majority. You just need an ordinary majority of the votes count. So this is a long explanation, but it's important with respect. What that means is, if the councillors had just remained in attendance, the EFF and the ANC councillors, even if they had refused to vote, a quorum would have been attained, and many, many decisions could have been made without them even voting. All of the decisions except those contemplated by 160 sub 2. But of course, because they didn't remain in attendance, and because they walked out, and of course, the undisputed facts are that they walked out in an effort to derail the council. But because they walked out, there was no quorum. Let me deal with the question of the mayor, Justice Chiki, because the mayor is an issue. Let me make the point to you that the election of the mayor is governed by Schedule 3 of the, in fact, it's the Speaker, the Mayor, it's the Speaker and the Mayor. It's Schedule 3 of the Structures Act. So again, I'm now back in the Structures Act. And when you read Schedule 3 of the Structures Act, what you will see is, of course, you need to have half your members there because otherwise you're not quorate. And what happens then is under Schedule 3 is you have to call for nominations. If only one candidate is nominated, then the person presiding must declare the candidate elected. There's no vote. That is item 5 of Schedule 3 to the Structures Act. If more than one candidate is nominated, then a vote must be taken. Everyone is entitled to cast one vote, and the person presiding must declare elected the candidate who receives a majority of the votes. So it's not a majority of the councillors, it's a majority of the votes. So if all the EFF and ANC members abstained, then the DA person would have been elected. And that's item 6 of Schedule 3. And item 7 of Schedule 3 and item 8, there's a whole elimination process to make sure that you're never left in a position that you can't elect a mayor. It's a very careful system designed to achieve that. And the only reason that it couldn't happen is because the meetings were not quorate. And the reason the meetings were not quorate is because of the ANC and the EFF councillors. Now that brings me to the remedy. And the remedy, we say, is item 14.4 of Schedule 1 to the Systems Act. And I'm now back in the Systems Act. Why Parliament decided to call one the Municipal Structures Systems Act, systems and the one structures, I can only think was to drive council to distraction. But in any event, I'm now back in the Systems Act. And in item 14.4, and that's the provision which was debated previously, perhaps I could begin with item 3 and 4. Item 3 of that schedule says, the councillor must attend each member of the municipal council and of a committee of which that councillor is a member, except when leave of absence is granted or where that councillor is required to withdraw from the meeting by the code. So you have to attend. And 4 says, there is a sanction for non-attendance. A councillor, 4.2 says, a councillor who is absent from 3 or more consecutive meetings or from 3 or more consecutive meetings of a committee, which that councillor is required to attend in terms of 3, must be removed from office as a councillor. So the system is designed to ensure attendance for the very reason that otherwise the system doesn't work. And then comes 14.4. And I should make the point that 14.4 was amended, you'll see there in 2008, if you've got the statute with the amended. It used to just say the MEC can take certain conduct. It now is express. It says the MEC for local government. So let me go back. 14 deals with breaches of the code. 14.1, 2, and 3 deals with what a municipal council may do for breaches of the code. And 14.4 says the MEC for local government may appoint a personal committee to investigate all alleged breaches of a provision of this code and to make a recommendation as to the appropriate sanction in terms of sub-item 2 if a municipal council does not conduct an investigation contemplated in sub-item 1 and the MEC considers it necessary. So the MEC is given a specific power to set up a person, to appoint a person or a committee to investigate breaches of this code, which include the duty to attend, and to make a recommendation regarding sanction if the municipal council does not conduct it and the MEC considers it necessary. And then 14.5 is a procedural provision, and 14.6 says if the MEC is of the opinion that the councillor has breached and that the contravention warrants a suspension, the MEC may suspend the councillor for a period and on conditions determined by the MEC, or remove the councillor from office. Now, just to be clear, if the MEC had gone down this route and decided that just a handful of ANC or EFF councillors had breached their obligations and would be suspended or removed, then the quorum requirement would be met, because suddenly the DA would have more than 50% and all of the problems would be resolved. In fact, not only would the quorum requirement have been met, but if they'd removed, even the voting requirement would be met, because the DA would have a majority in respect of an actual majority, because of course there would be vacancies and there would be no by-election yet, etc. So it lay in the MEC's hands. He had a statutory power to deal with this. And what we say is that when you consider less restrictive means before you dissolve an entire council and undo the will of the electorate, you must at least consider using your statutory functions. And this point is raised in the papers, and it's never explained why it wasn't used. In his argument, our learned friend for the government gives one answer. And the answer is to say, well, when the MEC tried to do this to the speaker, the DA complained and said it was unlawful. Well, with respect, whatever the rights and wrongs of the DA's stance, you can understand why the DA was antagonized when the MEC responds to this absolute disaster by investigating only one person, the speaker, and taking no steps against the ANC or EFF councillor, even though, as the papers reveal, his own official who had been seconded to attend these meetings said the problem is the speaker and the ANC and EFF councillors. That's in the papers. We've referred to it in our heads. So the short answer, Justice Chiki, is I accept that 139(1)B wouldn't have been a problem about the absence of a mayor. But if the disciplinary steps under 14 had been taken, that would have been an answer. And there's no explanation as to why that was not done.
Well, Mr. Bartlender, why then didn't you seek an order compelling the MEC to carry out his responsibilities rather than the order that seeks to compel councillors to be present for council meetings?
Chief Justice, that's a good question. And I think the answer, with respect, and the answer is because an order compelling them to attend would have an immediate effect. If the order is granted compelling them to attend, then they will attend tomorrow. If the order is granted compelling the MEC to do an investigation, then the council remains hamstrung until the outcome of that investigation and until steps have been taken and any judicial review proceedings of those steps. It's a much longer process. And so we sought an order which we sought to remedy the problem directly.
Well, if you had caused that to be initiated much earlier, considering for how long council has not been able to meet, that is the same period during which those steps would have been taken by the MEC, isn't it? And secondly, you're then leaving this executive responsibility to the executive. The executive at the local government and the executive at a provincial government, trying to deal with matters that fall squarely within the area of responsibilities of the executive, rather than have a situation where the court now comes in and orders councillors to stay to attend meetings and never to leave. Doesn't, I think it's Mr. Semenya, doesn't Mr. Semenya have a point to the extent that he senses some judicial overreach there in circumstances where you can't say that the executive would not itself have been able to address that, or could not itself have been ordered to cure this problem?
Justice Mogoeng, if you would give me the leave, I would like to return to that when I come to the mandamus, because I'm going to address that directly. But it seems to me with respect that one mustn't conflate two questions. The first question, and the one I'm addressing now, is Justice Chiki's question, which is whether the MEC had in his hands an alternative means of resolving this problem. And he did. He had the means in 14.4. And his failure to do so, and his failure to offer any basis for doing so, renders his decision unlawful. A separate question which you raise, and with respect is very important, is what is the appropriate remedy now? And I'll come to that when I deal with the mandamus, and I will squarely address the overreach point. But for now, I make the point that the mere fact that my client didn't compel him to adhere to his legal obligations could never suggest that that means that his decision is not unlawful. He had the power to fix this himself. He didn't do so, and he has never explained why. And on that basis, his decision is unlawful. But I will squarely address the judicial overreach point in just a minute or two, if that's convenient, Chief Justice.
No, that's okay.
Thank you. I'm very grateful. So we say, just to finish the point, then we say that there is simply no showing on these papers that there was any consideration, let alone any proper consideration, given to the less restrictive means approaches. And on that basis, it's unlawful. And in fact, it goes further, Chief Justice, because in fact, there's not even a showing that the responses were considered. So it's one thing to say, I considered the responses, I wasn't satisfied, so I dissolved. And then you can debate less restrictive means. We say that there isn't even a showing that the responses were considered. And could I just explain why? Because it is important, and it emerged from the questions that the court put to my learned friend. The first reason is that the answering affidavit doesn't say so. There is nothing in the answering affidavit to say that the December and February responses were considered by the MEC or the provincial government before it took its decision. And if I could just give the court a reference, the court doesn't necessarily need to go there, but if the court would make a note, it is volume 4, page 386 to 88, paragraph 74, especially 74.1.3. And what you'll see there is a long debate about whether these were responses by the city or responses by the speaker. And of course, the speaker explains that the response from the speaker became because the council couldn't meet because of this very problem. But what is said there is that it's not true that there was any response from the city. And in fact, in 74.1.3, it said it's improbable that the city of Tshwane responded, and the DA is deliberately misleading the court in making such a bold claim. What is not found there is anything to suggest, but by the way, I did consider the response that the speaker sent me, nothing at all. And so it's because my learned friend, Mr. Ngulkatobi, is unable to point to the papers in this regard, that he instead, the affidavits, that he instead starts to look in the annexures. And so the court was treated to the spectacle with respect of my learned friend seeking desperately in a series of annexures to find some indication that the December response and the February response were considered. But that cannot assist him for three reasons. The first reason is that it is impermissible. This court has repeatedly laid down the principle or endorsed the principle from the SCA that you cannot go and trawl through annexures to find things when the point is not made in the affidavit. Could I just give the court two references? The first is Malusi versus Vogus, 2016, volume 3 of the South African Law Reports, page 370, a decision of this court at paragraphs 27 to 28. And the second is Genesis Medical Aid Scheme versus the Registrar, 2017, volume 6 of the South African Law Reports, page 1, a decision of the Constitutional Court at paragraph 171. That is the judgment of Justice Zondo, but it's concurred in with by the majority, and it expressly endorsed what was stated in the SCA in D.F. Weervil, which said that the affidavits constitute both the pleadings and the evidence, and the issues and averments in support of the party's case should appear clearly therefrom. A party cannot be expected to trawl through lengthy annexes to an opponent's affidavit and to speculate on the possible relevance of fact therein contained. Trial by ambush cannot be permitted. And with respect, that is exactly what's happened. because these are these lengthy annexures and a line is plucked out in an effort to demonstrate something. I'm going to demonstrate that that even that doesn't establish it. So the first reason is that there's nothing on the papers, on the affidavits. The second reason is that you can't refer to annexures to fix the problem. The third reason is that even the annexures don't establish it, because, Chief Justice, you were taken to various passages and you said to our learned friend, but are you showing me what was considered at the time, or are you showing me pre-existing information? And our learned friend conceded that what he was really referring to was pre-existing information. Could I just remind the court, you were taken repeatedly to page 79 of the papers, volume 1, page 79, where reference was made to the Municipal Public Accounts Committee report. And so our learned friend says, well, you see there, the Municipal Public Accounts Committee report indicated that there'd been all this wasted money. Could I just, as an aside, make the point? That same page makes the point that the city had been achieving unqualified audit opinions for the last 3 years. Most municipalities in this country would be delighted to have such a position, but be that that's by the by. But our learned friend says, look at that report from the Municipal Public Accounts Committee, and that's the report referred to. But what is clear is that that report, although it might have been referred to in the December or February response, in fact, predated that. Because when you go to page 134 of the papers, that's volume 2, 134, you will see volume 2, 134, at the foot of the page. This is in a document from the MEC dated 6 December 2019. In the second last paragraph, you will see the very same MPAC report. So this MPAC report, which is referred to, existed prior to December 2019. The mere fact that it happens to have been referred to in February doesn't prove, in the submissions, and that it was referred to in February, doesn't prove in any way that regard was had to the December or February submissions. So even if you would permit my learned friend to have regard to the annexures, despite this court's jurisprudence, it doesn't establish his case at all, and neither did any of the other annexures. But thirdly, it is inconsistent with what the MEC and the Gauteng government actually did. And in this regard, if I could commend to the court what appears in volume 1 at page 31, paragraphs 83 to 84. Because you will recall that what happened was, on paragraph 83, it's recorded, the annexure has been dropped off, but it's recorded here. On 4 March 2020, so 4 March, the MEC wrote to the Speaker, inquiring whether the section 139(1)A directives, that's of course the February directive, whether is the January directive, yes, served before the council. And if so, he requested a copy of the resolutions authorizing her reply. The MEC called for a response within 3 days. Despite the MEC having afforded the Speaker 3 days, the Gauteng EC then resolved to dissolve the city on 4 March 2020, and the decision was announced on 5 March. So far from there being any suggestion that they were giving serious consideration to the February response, on the 4th of March, they asked whether the February response was even authorized. They give 3 days for an answer, and before an answer is received, they've already dissolved the council. Now, when you look at all of that, it's plain in our submission that there was no consideration of the February response. And I would again say on the Hammanskraal issue, I gave you the references earlier, where the point was made squarely that there was no consideration, and that was met with a bald denial and no explanation. So where am I, Chief Justice? I am at the position of dealing with the question of the substantive lawfulness of the dissolution, and I'm making the point that there was no showing of a consideration of other options under 139(1)A, 139(1)B, or the other powers of the MEC. In fact, there's not even a showing that there was the response considered.
May I take you back to the majority? I just need to understand how it works.
Yes, of course.
And just so that I can work it out in my own mind. DA and, I beg your pardon, ANC and EFF members together.
Yes.
How many are they, and DA members, how many are they? I'm trying to work out this majority because yes. If, just for argument's sake, the DA, let's say all council members were 40, all councillors were 40, and the DA has 10, one ought to be able to work it out in his mind how that term would help resolve the problem and why was it necessary for an order like this to be made.
Yes, Chief Justice, I knew you were going to ask me this, and I made a note last night that I must find you a reference, and then I forgot. Could you give me one moment? I'll get my learned friend to find a reference in the papers. I do apologize. I thought about it just before I went to bed, but I should have written it down. My learned friend will find me a reference in a moment.
All right, thank you.
So could I then, so I don't delay you, Chief Justice, could I then just deal with the fourth point, which is the failure to engage in any form of consultation, and then give you this answer as soon as I have it? I don't want to delay the court, if I may.
Always.
Thank you so much again. So I've explained why the decision was invalid on the basis invalid of the failure to consider alternative means, and invalid on the failure to consider the submissions. On that basis alone, I submit it's unlawful. And that's even if you assume in favor of the MEC that these were unfulfilled executive obligations. On that basis alone, the decision is invalid. But then there is the question of the procedure adopted, and this is now my fourth point. Yes, my learned friend has found it. It's at page 591, which is in volume 6. What you will see there, Chief Justice, is that there are 108.
108.
I'm just worried that that's not correct. There are 108 proportional representation councillors, but that's not the full figure, because I think, aren't there 200? I'm sorry, we will come back to you with these figures. We should have them at our fingertips. I think those are the PR councillors, but there are also the constituency ones. I'll get
I just want the total number and how many are for which party and so on, so that I can tell whether your order is based on hope.
No,
that
it's not.
Some miracle would happen, or is it based on practicalities?
Yes, I'm going to demonstrate to you that it's based on practicalities, not on hope, but I just need the numbers to do so, and my junior will find the figures. But so the point is, I'm now on to the procedural question, and the question of whether the right procedure was followed. And of course, we deal with that in our heads of argument at paragraph 87 to 91, and we commend that to you. Our learned friend, Mr. Nukatobi, appeared to concede that there should be a warning from the provincial government that it was contemplating dissolution. He said in answer to questions that he was not suggesting that there shouldn't be a warning. And I'm going to demonstrate in a moment that that must be so. But our learned friend, Mr. Semenya, disagrees. He says there is no duty to engage in any form of consultation at all. And he makes the point that, that this is not required in the Constitution. But with respect, his argument is incorrect for three reasons. And the first reason is that it is required in the Constitution, because that's what section 41(1)(h)(3) says. 41(1)(h)(3) says, and if I could read it, all spheres of government and all organs of state within each sphere must cooperate with one another in mutual trust and good faith by informing one another of and consulting one another on matters of common interest. So the Constitution is express. All spheres of government must cooperate by informing one another of and consulting one another on matters of common interest. And the question of whether the provincial government is about to dissolve the municipal council is self-evidently a matter, in order to serve the citizens of Tshwane, is self-evidently a matter of common interest. So just as in Doctors for Life, this court took a provision which spoke about a duty to facilitate public involvement, held that it was justiciable, and struck down laws that had been enacted without complying with it, exactly the same is true here. So there is a duty of consultation expressly, and that's good enough with respect. But even if that were wrong, or somehow to be ignored, the important point is what is said in Albert. And what Albert says and the point was made by Justice Jafta, is Albert creates a duty to engage in a rational decision-making process. Now, sometimes that requires an opportunity to be given representations, and sometimes it doesn't. So in Albert, this court held that it did create a duty to hear representations from families in order to give effect to the objects of the amnesty process that President Mbeki had adopted. Whereas in other cases, for example, the SCA has held in a matter called Kubukeli that you don't need to engage in a consultation process with the person affected when all you are doing is, as a municipal council, is adopting a report which recommends investigation into someone. That's Kubukeli versus National Treasury. I lost that case, so I remember it with some disappointment. But it depends on the circumstances. And in Scalabrini, of course, the SCA held, leave to appeal ultimately refused by this court, that there was a duty to engage in a consultation process with refugee organizations before you close a refugee reception office, even though it was legality. So the test is, what does a rational process require? And we submit that it is plainly clear. How can it ever be said, when you are taking a decision that is going to have an extraordinary and immediate adverse effect on the councillors and the council, and which purports to take a decision, and which purports to be a decision in the interests of the very citizens that elected that council and councillors, and which would undermine those citizens' votes, how can it ever be said that it is rational to take that decision without at least giving them an opportunity to make representations? How can it ever be said that it's rational for the Gauteng government to take that decision, knowing that the jurisdictional facts are it has to be satisfied that there are exceptional circumstances and that a dissolution is warranted and that no alternative means will suffice? How can the provincial government rationally reach that conclusion without hearing the council that is closest to the ground and most likely to have a useful perspective to be? Of course, they might disregard, they might ultimately reject that perspective, but it's plainly a valuable and critical perspective. We submit with respect.
I'm sorry, Mr. Butland.
Yes.
In that inquiry, is it not important for one first to identify the purpose
Yes.
that the process is seeking to achieve? And then you ask whether the procedure followed, which does not include consultation, would reasonably achieve that purpose.
Yes, with respect.
So could I hear you on that?
Yes.
Because I was afraid that you're moving forward to some other things without having really identified that purpose for us to move away from that issue of procedural fairness, because procedural fairness, it requires me to be heard. It does not need a link between me being heard and the purpose that is to be achieved.
Yes. I would submit that the purpose is twofold and that the two purposes are linked. The one purpose is to ensure the fulfillment of executive obligations and service delivery in a municipality. That is the purpose of 139. It is a provision which is designed to remedy a failure to fulfill executive obligations and service delivery. And it says, this is a provision which enables you to do so. So that is the one purpose. But the allied purpose is a purpose that you may not, it is to do so only when that is necessary, so that you don't unnecessarily intrude on the autonomy of local government and unnecessarily undo the will of the voters. So it is, and that's really what this court articulated when it dealt with the powers of intervention, albeit relatively briefly, in its earlier judgments. Because when you have regard to what this court said, I'm just finding the reference for the court. When you have regard to what this court said in Johannesburg Metropolitan Municipality versus Gauteng Development Tribunal, it explained that Section 139 is a limited and tightly constrained power that can only be used in exceptional circumstances only temporarily and in compliance with strict procedures, because the Constitution doesn't enable a freewheeling intervention by provincial government in local government or by national in provincial. And you read that, and you then read that together with what was said in the second. So that's Johannesburg Metropolitan Municipality at paragraph 44, and we cite that in footnote 38. And you read that together with what this court said in the second certification judgment, and we cite that at footnote 47, it's paragraph 124. And what this court said was that this power had to be construed in the context of the Constitution on the whole, and the provision that it makes for the distribution of powers between the levels of government. And this would not ordinarily include the assumption of the powers of one sphere of government by another, but instead a resort to the procedures established for the promotion of intergovernmental relations, that's what it says, and the settlement of intergovernmental disputes, and that appropriate steps would not include resorts to means that would be inconsistent with Chapter 3, and particularly the obligation under 141(1)(g) to exercise its powers in a manner that doesn't encroach on the geographical, functional, and institutional integrity of provincial governments. That was national in province. So what we say is that there are twin purposes. The provision enables intervention to ensure the delivery of services, but it does so in a limited way so that it doesn't enable the incursion into geographical, functional, or institutional integrity. And when you have those purposes in mind, Justice Jafta, it's difficult to see how you could ever take the decision by yourself without at least having heard what the other branch of government had to say.
Thank you.
Thank you. Justice Majid, I hope that that has addressed the question of the effect of the Law Society case, because as I understood what the Law Society case did, is it summarized this court's jurisprudence starting from Masetla, and that what it did was that Masetla was decided, of course, in an era where the principle of procedural rationality had not yet been laid down. And so Masetla was argued on a procedural fairness basis. And this court said procedural fairness is not an incident of executive power, only paja. But in Albert, this court said that although procedural fairness is not an incident of executive power or legality, procedural rationality is. And so it drew that distinction. And so I hope that I've demonstrated that on the facts of this case, not the facts, but in the context of this case, it could only be procedurally rational to engage in some form of hearing on the question of dissolution, some form of representations, I should say, and it doesn't have to be a hearing.
Yes, thank you, Mr. Butlander.
Thank you, Justice Majid. So we submit that on the basis of 41(1)(h)(3) alone, but in any event of the basis of procedural rationality, there was a duty to hear the city and its councillors. And our learned friend, Mr. Ngukatobi, does not suggest that that was done. He expressly conceded that there was no warning given to the city council or councillors that dissolution was contemplated. And that's absolutely clear with respect. Because when you go and read the notices, there is nowhere that dissolution is mentioned. Nowhere. And of course, you can't make meaningful representations on dissolution if you don't know that dissolution is being contemplated. And so our learned friend, instead, every time he was asked this question, he had two answers. His first answer was to say procedural rationality is not before this court because of the cross-appeal issue, but I've demonstrated with respect that that is wrong. His second answer was to say, but it doesn't matter because substantively, exceptional circumstances were satisfied and substantively, the dissolution was warranted. But that with respect, although he doesn't use the phrase, is exactly the no difference principle that this court has repeatedly rejected. This court has said time and time and time again that you do not ask whether a decision is procedurally unlawful by saying, would a hearing have made any difference? You ask the opposite. And it cited John versus Rees, and it said so in Allpay, and it said so in Kwelani. The latest statement is this court's decision by Justice Madlanga in Van der Walt versus the state, 2020, ZACC 19. It's a decision from July this year at paragraphs 27 to 30. So when my learned friend accepts that there was no notice given of the intended dissolution and no opportunity to make representations on that score, that is with respect the end of it, the decision, because that means it was procedurally unlawful and it falls to be set aside. My learned friend, Mr. Cement.
I'm sorry, Mr. Butland. If one considers the facts, I understand at the level of the law, the submission that you're making, that procedural rationality required counsel being afforded an opportunity to make representations. But in light of the facts of the case, that counsel could not meet, we know. And the directives which were sent by the MEC to counsel, it was not possible for the speaker to place them before counsel because they couldn't be correct. Could it then be said that they were exempt or excused from affording counsel, because it has to be counsel in its collegial form, not individual counselors? Could it be said that they were excused not to do so at a factual level, but even though the law required them to do? Because the law cannot require you to do that which is impossible,
Yes.
isn't it?
Justice Jafta, ironically, that case might have been better for them if there was a specific requirement of consultation with the counsel. But that's not what we're debating. We're debating a procedurally rational process. And so my answer is twofold. Firstly, procedural rationality required that they do the best they could. So if they couldn't hear the counsel, they could have at least heard the counselors, or they could have heard the parties, the political parties represented, and taken them into account. That would have been a rational response. But the second reason is that they don't accept on these papers that there was any duty to hear anybody. And so if it's going to be justified as procedurally rational, there has to be an explanation on these papers saying, we would have heard the counsel, but because the counsel was dysfunctional, we decided there was no point. And maybe one day there'll be an interesting debate about that, but that's not the case that's made up.
Thank you.
Excuse me, Mr. Badlander.
Yes.
But if I recall very well, is that it is not the DA's case that the directives were put before the council for adjudication or deliberation.
No, they weren't.
And following from what my brother Jafta has put to you, would you then say, no, before that, the speaker responded to in February, and the MEC wrote back to say, I'm paraphrasing, indicate to us or to me who are the principal stakeholders that you are purporting to represent.
Yes.
And in essence, as I understand it, from the MEC perspective was, you had no business to be responding to a letter without any mandate.
Yes. Justice Matopo, I do understand the question, but with respect, the answer is no good. And the answer is no good for this reason. I said they could have consulted the councillors, they could have consulted the parties, and my learned friend in a stage whisper said, or the office bearers. And that's with respect correct. The speaker was the duly elected speaker of the Tshwane Council. Now, of course, it's better to have the council itself respond, if possible. But for all of the reasons in this case, we know it wasn't possible. It's then necessary to do the best you can. And doing the best you can is allowing at least the speaker to respond, or some other official. And if you're worried that the speaker is a DA hack and you don't want the speaker to respond, then you can get everybody to respond and offer everyone a chance. But the speaker is a duly elected office bearer in power or in office at the time. If you want somebody to respond, she was a good bet, or he, I can't remember.
Is she not the channel upon receipt of the correspondence from the MEC? Wasn't she duty bound to then disseminate that information to the councillors so that whatever response she gives to the MEC would be a product of what councillors have to say, maybe even give them timelines? And if you don't respond by such and such a date, I will assume that you leave in the matter in my able hands as counsel without argument would often say.
Yes, Chief Justice, that may be correct, but of course, and that might have been, if we were in a world where what had happened was, there was a letter written to the Speaker which said, I'm contemplating dissolution, make your submissions, have the council make submissions, and the Speaker didn't do that, then maybe we could say this was procedurally rational. But there was never any letter sent to the Speaker or anybody saying we're contemplating dissolution. So I accept that the Speaker ordinarily is required to get a mandate from the council, but here there was not even a letter sent to the Speaker raising the question.
Mr. Butlander, before I forget, why do you prefer this phrase, less restrictive means? Can't you find alternative English words that actually communicate what needs to be communicated here? Why do you make yourself look like you're drawing Section 36 into this thing when in fact it doesn't apply?
Laziness, Chief Justice, is the answer. We shouldn't. The answer is we should say appropriate means, and we should say a consideration of alternative means, or as the SCA put it in, I think in Overberg, less invasive or less drastic means. So you're right with respect. Less restrictive means is the wrong language because you're not limiting rights. I think the language of the SCA in Overberg is better than the language I've used.
All right, I had here a less intrusive measure, but it accords with what you're saying.
Yes, indeed.
And the next question, for what it is worth, when Section 139 1C has been invoked, do councillors still get paid?
Justice, did you say
for what it is worth?
Did you ask whether they get paid?
Yes, when 139 1C is operational.
No, Chief Justice, they do not get paid, and they have not.
Okay. No.
That is a problem, which I'll come to in a moment. But
no, that's just what I wanted to know. Okay. All right.
So, Chief Justice, we say for the reasons articulated on the procedural ground 2, the decision falls to be reviewed and set aside. Could I now deal with the 5th point, which is the mandamus, and if you just give me one moment to get them. Chief Justice, I'm now moving to the mandamus, and can I begin with your question, which I promised to get back to you on? And I'm told
that the numbers.
I've got the numbers. Could I give them to
you? To me?
The ANC, and this does appear from page 591. It was the right page, but I was reading too quickly, I'm told. The ANC has 89 seats. The EFF has 25 seats. The DA has 93 seats. The PAC has 1 seat. The ACDP has 1 seat. There is another party which has 4 seats, and COPE has 1 seat. And
so it's a total of what?
A total of 214.
214.
Now,
if everybody is participating in the vote,
yes,
DA won't get the majority, isn't it? Unless other parties support it.
Correct. But the point I was making earlier.
While I'm there, even if PAC, ACDP, another party and COPE were to support it.
That's correct.
So tell me why an order made facilitates what you seek to achieve under the circumstances.
Let me tell you exactly.
And I move from this premise, I'm alive to the fact that I may be causing you to traverse issues or facts that were not traversed before, but I just want to work it out in my own mind.
No, I understand.
You see, from the look of things, it may well be that the ANC and the EFF really wants to frustrate your client.
Yes.
And if that is so, I'm just coming up with hypothetical scenario. If they really want to deal with the DA,
Yeah.
all they have to do is come and vote. Now that there is a court order forcing them to be there, come and vote, and the DA will never get anything done. And if that is so, does that not point to the need to have an administrator appointed as envisaged by 139(1)(c)? Because you'll never achieve what you seek to achieve anyway.
Chief Justice, can I begin by explaining why this solves the problem and then move to your question about what if the
Sure,
ANC
sure.
Let me take the election of the mayor. At the moment on the election of the mayor, if the meeting to elect the mayor were to be held tomorrow and the ANC and the EFF were not to attend or at all, or were to attend and then walk out, there would be less than the required quorum because there would not be 108 there. So nothing could happen.
Sure.
Now assume that they are required to attend, and we then tick the quorum box. The DA will then nominate its candidate in accordance with Schedule 3 of the Structures Act. If nobody else nominates a candidate, then the DA's candidate is elected and a mayor's in place.
If I may just interrupt you there so that we move together.
Yes.
But these are the people who want to frustrate you, who understand the system and maybe even take legal counsel.
Yes.
They won't allow you to get away with it that easily. So move to the next possibility.
Yes.
That is more favorable.
So scenario 2 is that the DA nominates its candidate and the ANC nominates its candidate and the EFF nominates its candidate. They all say, we can't stomach the others, we're going to nominate our own candidate. Then what Schedule 3 says is that there is everybody votes and the candidate with the least number of votes falls out. So let's assume that the EFF votes for the EFF, then the EFF's candidate will be left with 2. Now there is a runoff between the 2.
And they have a common enemy in the DA, so to speak.
Well, if they have such a common enemy that the EFF is prepared to vote for the ANC's person, then a mayor will be elected. My client will be unhappy because it won't be a DA mayor, but there will be a mayor and the problem will be solved. Alternatively, if the EFF can't stand the ANC and they can't bring themselves to vote for the ANC and the EFF abstains, then my client's candidate will get 93 votes and the ANC's will get 89 votes and my client's candidate will succeed.
By the way, and what about spoiled votes? Are they taken into account?
No, it's a majority
for the purpose of determining where the majority lies.
No, it's clear from Schedule 3 that the way it's meant to work is that you have an elimination system and it means a majority of the votes cast, which means if you spoil your ballot or you abstain or you refuse to get up, then it doesn't count. It's the number of ballots.
No, but when you spoil your vote, it's when you vote, for instance, for 2 or 3 people, or you vote for everybody on the ballot. You have voted, you just didn't vote correctly.
Chief Justice, my understanding of the schedule, and it must be so because the schedule is specifically designed to always make sure that there is a winner. It must mean that it's a majority of the valid votes cast. Because when you read the schedule in your own time, Chief Justice, you will see it's a very careful process to make sure that there is always a winner, provided that there is a quorum.
Well, my next remarks are to be disregarded.
Yes.
I always run these elections in the National Assembly, and to the best of my recollection, even spoiled ballots are counted, but that's besides the point. Well, maybe it's different at the municipal level.
Yes, this is a specific provision designed to deal with municipalities. Okay. And you will see, as I say, that the whole process is designed to ensure that you are not deadlocked. With a casting vote and everything else. And so it would make no sense if you couldn't do it any other way.
So in other words, Mr. Butlander, there is a possibility that a mayor may be elected. The only problem would be if people are so calculating that they will make sure that their number squares up with that of the DA all the time, with the result that there is no majority. But otherwise, there's a possibility of a mayor being elected. That's what you would say.
I thought, yes, I thought there was even a deadlock breaking mechanism, but I can't see it immediately to hand.
Okay, okay. No, that's a side point. Thank you very much. I just wanted to clear it up in my mind.
Thank you. And let me say, Chief Justice, that the same applies to the Speaker. You know, the Speaker is also governed by this procedure. So the problem was a quorum problem. And the quorum problem is solved by the mandamus that was issued by the High Court if it is put into operation.
Well, now that we're talking about a mandamus, do you think it's defensible that the court made that kind of an order?
I do.
Instructing members of the executive to report for duty and to stay there, yes, as long as there's a sitting? Or is there an alternative route open to the executive itself, be it at the provincial level, to sort out their own problems?
Chief Justice, could I begin with why I say the order is defensible and then deal with the possibility of an alternative?
Sure.
And the first is, my argument would be more difficult if there was no statutory obligation to attend meetings. So I haven't looked at the parliamentary rules, but I'm not sure, for example, in the context of Parliament, whether there's an obligation in the same way. But what you've got here in the provisions that I've drawn to your attention in Schedule 1 to the Systems Act is an express requirement by law that you have to attend these meetings. And Parliament deemed it so appropriate that they said if you miss 3, you can be removed and suspended. So the court was not making up a rule that said you must attend. It was implementing the will of Parliament, which had already determined that. That's the first point. The second point, Chief Justice, is that this court has already made clear in calm that it is a blatant breach of obligations to try and undermine the behavior of local government. That's this court's decision in Calm versus the Electoral Commission at paragraph 122, where this court said this exact issue about people boycotting arose. And this court said, if either major party in the council were to boycott its proceedings in order to prevent it from operating, that would be gravely irresponsible. We should not assume that the governing party and the official opposition at national and most levels of government in this country would behave in such a fashion in Tlokwe. Councillors are elected to undertake the work of the council on behalf of the whole citizenry. Sometimes the tide of politics will place one party in the majority, sometimes the other. But it remains the duty of all councillors to facilitate and not obstruct the workings of council. For councillors to continue to draw their salaries while refusing to attend meetings and thereby stultify the working of the council would be a breach of their obligations as councillors. And then there's a reference to the code. The third reason, Chief Justice, is that it must be recorded what the stance of the parties was about this mandamus before the full court. There were 3 parties who are at issue. The provincial government, represented today by my learned friend, Mr. Gukai-Tobi, did not oppose the mandamus at all, apart from on the question of remedy. You will see that in the, on the question of urgency. You will see that in the answering papers. I'll get you a reference. But there was no substantive answer given to the mandamus. The EFF, who is before you today, did not oppose the mandamus at all, even though it was sought against them. And when my learned friend says, well, his client thought the order granted would be different to the one granted, it was granted in the exact terms in the notice of motion. So the EFF is faced with a mandamus to do this. It and its councillors do not oppose. And the ANC does oppose, but when the order is granted, the ANC applies for leave to appeal and has now apparently abandoned its appeal because it's not here. It doesn't file submissions. It doesn't explain what's going on. It just simply doesn't arrive. So we are in a situation, Chief Justice, where the MEC and the provincial government did not oppose. They didn't say it's a breach of our duties. The EFF did not oppose. And the ANC, who opposes, no longer seeks to appeal against the order. I'll just give you a reference. The reference to the government's answering affidavit is page 362, which is at volume 4, paragraph 16.2. They only opposed the mandamus and interim and mandamus on the question of urgency. So, Chief Justice, this is not a case where the MEC said to the full court, you are usurping my functions and you should let me do this. In fact, there was no opposition at all. And the councillors who are bound by the order One set didn't oppose, the other set did oppose, and is now not appealed. In other words, they've effectively conceded the order. When you take all of that into account, Chief Justice, and you take account the need to grant just and equitable relief under which means effective relief under section 172(1)(b, we submit that it is a perfectly appropriate order. And added to that, we would commend to this court its own judgment in the matter of Trencon, because in Trencon, what this court did was it considered whether a remedial discretion was open to reconsideration on the basis of correctness. Trencon is Trencon versus the Industrial Development Corporation. It's 2015, volume 5 of the South African Law Reports, page 245. It's a decision of this court at paragraphs 82 to 92. And there, Justice Kampepe at some length explained why a remedial discretion is a true discretion, and a court will not disagree merely because it would have granted a different order. There's got to be something more, a demonstrable blunder, a wrong principle, etc. So what we submit with respect is that this was a perfectly acceptable order and a perfectly correct one, but at the very least, there isn't a basis for this court to interfere. It is true, I accept, that one could have crafted a different order. One could have said that the MEC is required to take the steps envisaged in the Act to discipline. But with respect, Chief Justice, when you read these papers and you see the way the MEC has dealt with this, you will be unsurprised that my client did not regard the MEC as an honest broker in the middle of all of this. Whatever the rights and wrongs and lawfulness, the MEC appeared intent on causing chaos and disrupting the council whenever he could. He gets told by his own advisor in the papers, he gets told to look into the councillors, the opposition councillors, the EFF and the ANC, and the speaker. He only looks into the speaker. And in those circumstances, my client could hardly be expected to rely on him to do that.
Mr. Butler, there's something, I'm still worried about this majority thing. I'm sorry that I keep on taking you back.
Yes.
If out of the 214 councillors present, only 50 decide to vote,
yes,
for the election of a mayor or the speaker,
yes,
on your reasoning, because they would be the only ones who voted, that vote ought to carry the day.
Chief Justice, it's not my reasoning with respect, it is correct, because that's what Schedule 3 to the Systems Act says. It specifically speaks about the majority of the votes cast and not the majority of the councillors. By contrast,
does it say and not the majority of councillors, or are you reading that into what has been said?
No, I'm reading the contrast between that and what is said in section 30 sub 2 of the Systems Act, which speaks about the majority of the councillors. So when you read these two acts, and of course they all speak to each other and they're a package, some things require a majority of the councillors and other things require a majority of the votes. And the mayor requires a majority of the votes.
Well, this all happens in a democratic setting, isn't it?
Yes.
What happens there is supposed to be some replica of what ought to happen in a democratic setting.
Yes.
Now, if only 50 people out of 214 people vote, for whatever reason, just as people can walk away from their responsibilities, let's assume that it's only 50 who decide to vote. You are saying that ought to be regarded as the necessary majority for the purpose of electing a mayor and the speaker. That's how we must understand the meaning of that schedule to be.
I'm saying, Chief Justice, that the schedule is absolutely clear that the schedule read with the Act, there needs to be a quorum of 50%. So if more than 50% don't attend, then nothing can happen. But once you attend, then it's a majority of the votes cast. And that is for two reasons. The first reason is if you choose in accordance with your democratic right not to exercise your right to vote as a councillor, that's fine. But then you can't complain when the votes of others carry the day. And secondly, the entire system is designed to ensure that the city is not left without a mayor. And I found the reference I was missing, Chief Justice. It's 8 sub 3 of Schedule 3 says that even if they got identical numbers of votes after the meetings, then it contains a specific provision which says, then the person presiding must determine by lot, in other words, by chance, by random draw, who will hold office. So the whole system is designed to ensure that the one thing you can't have is no mayor or no speaker. And the only reason
so it's very much like the general elections where the majority may decide not to vote and only a smaller number of the total population votes, but that doesn't stop a government from being elected.
I should have made that point, but yes, it's exactly that. You're quite right with respect, Chief Justice.
Mr. Patlenda, what is the position in respect of the functions that are set out in Section 162 of the Constitution?
Section 160 sub 3.
Sub 2, the passing of the bylaw and the approval of budgets, etc.
Yes, so I accept, Justice Mhlantla, that that is a different situation, because when you read Section 160 sub 2 together with Section of the Constitution, together with Section 30 sub 2 of the Systems Act, the Structures Act, then you will see that those require a majority of the councillors. So I accept that in this situation, the mandamus would not necessarily remedy all of the problems in the sense of causing a budget to be passed, etc. But the world in which we are in is that there is a budget in place because the budget has been put in place by the administrator. And so, and of course, there are bylaws in place because there have been bylaws in Tshwane for many years. So I accept that there remains potential difficulties, but it's not the same difficulties as were the case previously, because the previous position was that there was no quorum, so you couldn't do anything. You couldn't elect a mayor, you couldn't pass a budget, you couldn't pass bylaws, you couldn't do anything at all. Now you would be able to elect a mayor, if needs be elect a new speaker, and you'd be able to do everything that doesn't fall within Section 160 sub 2. And the irony is that the appointment of the administrator has resolved some of the challenges at the moment, and it will enable the council to go forward.
But what about the next financial year?
Well,
once you've removed the administrator.
Well, let me speculate as to what may happen. If there is a requirement that people are meant to attend the meetings, and so the meeting can engage in business, and people start to frustrate the business of the council, then there might be a need for some sort of disciplinary action, and the council will exist, and you can try and remove people, and if people are removed, then there would be a majority. Or the MEC could do what you suggested, Chief Justice, and he could seek to remove people. But the point is, it's the point that this court made in calm. This court can't make an order, or I mean, put differently, this court can't refuse to make an order because of a fear that people will deliberately breach their obligations and stultify the council. That's exactly what this court said in calm. And so we submit that that means it's an appropriate order.
Well, when there is a relatively cleaner alternative in the form of the administrator will be able to do everything.
No, but with respect, Chief Justice, the question is not the cleaner alternative. The question is, what does the Constitution require? And the Constitution requires that you can only unseat the will of the people and those elected by them where the requirements of 139(1) are met. I've demonstrated to you that that's not the case, and we're now debating remedy, and it can't be the case.
Well, maybe I should have said, what if the likelihood of executive obligations being carried out is dim unless it is an administrator who assumes those responsibilities? You know in advance that had it not been for this administrator, there wouldn't have been a budget, there wouldn't have been appointment. Why not stay with that? Because it seems to work challenged as it is.
Chief Justice, because with respect, we are conflating the question of lawfulness and remedy. If that was to be the case, that it could never be anything else, that this was the only way it could work, that was the case that had to be properly made out on these papers by the MEC and the government. They had to say, we considered all of these options, none of them work for the following reasons, and we therefore rejected them. And we did so after hearing from the Speaker and the councillors. But they don't say that in the papers. They didn't consider the options. They didn't hear from the Speaker and the Council, and therefore their decision is invalid. All we are left with then is the question of what is the appropriate remedy. And my submission to you is that the mandamus is an appropriate, just and equitable remedy.
Whether it will work going forward or not.
Yeah.
Well, Chief Justice, my submission is it will work, but at the very least, this court cannot assume that it won't work and can't deny my clients effective relief on the basis of a concern that some councillors might try and stultify things, because that's what this court said in calm.
Mr. Patlenda, excuse me.
Yes, Justice Matoko.
The order says they must attend and remain in attendance.
Yes.
Is my understanding correct that if for any reason, say there is an item on the agenda that the particular councillor may or may not like, if he leaves, he is in contempt of the court order?
If he
Secondly,
sorry.
if he leaves the meeting, he is in contempt of the court order.
If he leaves,
And would that also mean that if he has to leave, he must have a lawful reason why is he leaving the meeting?
yes,
But
that
isn't that taking a step too far? I don't want to say overreaching.
Justice Matoko, you are correct with respect with the wording of the order. It says they must attend and remain in attendance at all meetings unless they have a lawful reason to be absent. So if they have a lawful reason, then they will not be in contempt. But with respect, it doesn't seem to me that that is in any way impermissible or overreaching, because the function of councillors is that if they disagree with an item, they can speak against it, they can vote against it, they can abstain from voting against it, from voting at all on it, but they can't leave the meeting in order to break quorum. That is not a permissible response. And of course, if there's some other reason for them to be absent, because they are ill, or because they have an emergency, or because of anything like that, they would have a lawful reason and they wouldn't be in contempt. But what they can't do is deliberately break quorum. They can, as I say, they can vote, they can speak, they can abstain, but they can't leave the meeting in order to break quorum. And that, of course, is exactly what the schedule says. Schedule 3 says that they must attend unless they've got leave or absence in terms of an applicable law, or they are required to withdraw from the meeting.
But this order, as I read it, it just imprisons the councillors. They can't do anything. If you go there in the meeting and then you leave, you run the risk of imprisonment.
With respect, it doesn't imprison them. It requires them to do their job and for what they're getting paid.
Excuse me, but if you leave, if there's a court order that says you remain in attendance, and when you leave, you must leave with a lawful reason. If you don't, you would be found to be in contempt of the order.
If you let me take a step back. If you have a lawful reason, then there's no breach of the court order. If you don't have a lawful reason, then there is a breach of the court order. But of course, on the well-established authorities on contempt, you would only be in breach if you were acting willfully and mala fide. So if you leave mistakenly, or you leave because you've got to run to the bathroom, or you leave because you thought the meeting was over, you would not be acting willfully and mala fides. And so irrespective of whether you had a lawful reason, you would not be in contempt. So with respect, the concern is overstated. All this requires them to do is to do what the law already requires and to do their job. And the risk of imprisonment unnecessarily doesn't, in our submission, arise.
Mr. Badlanda, I have a slightly different concern, but let me establish whether my thinking is correct first. Is the obligation to attend meetings and remain in attendance, is it not located in the code? Or it sits outside the code?
I think it derives in the first place from the code, but it may arise as a general duty, but I accept that it derives in the first place from the code.
And if it is located in the code, because I see a provision in the code that deals with that, would it have been open to council or the MEC for that matter to order councillors to attend meetings and remain in attendance without following the procedure laid down in the code? Procedure of investigating first and finding that one is guilty of breaching the code.
Justice Shafter, I don't understand that the council has a power to compel people to attend. The council has a power to discipline people who don't attend, and that would have to follow the procedures set out in the schedule.
Now, but when the court grants a mandamus, it truncates that process. It doesn't go through the process of investigating first whether there was a breach and imposing then the sanction that is competent to the breach.
But the court is with respect.
It seems to me then that the solution that the court comes with is a solution that is sourced outside the code itself. Now the question is, where the law creates a breach and establishes how that breach should be dealt with and it be enforced, can we source the remedy of enforcing it outside that law?
I understand. With respect, my answer is that you can for the following reasons. Firstly, one needs to draw a distinction between punishment for a breach and an order preventing breach in the future. What the code deals with is punishment for a pre-existing breach. So it says where you breach your obligations, you can be an investigation and you can be suspended and you can be removed. And I accept that in order to do that, you need to follow the processes. But this court and the High Court is not punishing people for a breach. It is simply granting a mandamus to say people must comply with their legal obligations, which is what always happens in the case of a mandamus. And so although the obligation to attend flows from the code, there is nothing impermissible about such an order. As I say, courts grant mandamuses all the time, and Section 172 requires the granting of effective relief, or just and equitable relief, which this court has said since Fose includes effective relief. And so therefore it's perfectly permissible to do so. I do accept that it would be different if the court had said, we hereby declare that all of the councillors who did not attend are to forfeit their positions or to be suspended, but that's not what the court did. It's a forward-looking remedy rather than a backward-looking punishment.
Is it applicable to all councillors or those who are guilty of collapsing the quorum so that the meeting should not run? That is the order.
The order is that it applies to those who were guilty of collapsing the quorum. It says the 13th and 14th respondents, and the 13th, this is at page 743, and the 13th and 14th respondents are the ANC and EFF councillors. But as I say, it might have been different if the answer had been given by Councillor Smith, who said, I don't know why you're seeking that order against me. I'm a member of the EFF and I've attended every meeting. But Councillor Smith, they were all cited in their individual capacities. None of them come to court to say, this shouldn't affect me. And as I say, the EFF councillors didn't oppose. The ANC councillors did oppose, but not on that basis, and they don't seek to appeal.
Okay.
Mr. Butlander, just a point of clarification. I think it's important to this point about the remedy and the alternative suggestion.
Yes.
Yeah, at page 591, the numbers given there, we know the councils are composed of PR councillors, that's proportional representation councillors, and then ward councillors.
Yes.
The numbers there appear to set out 214 ward councillors. And then on top at 4.2, those are the PR councillors. Does it have any effect on the numbers you've given to the Chief Justice earlier? Because it seems to me that the council consists of more than 214 councillors. Those are only ward councillors. You must add the PR councillors. Or am I mistaken?
With respect, that is a typo. It's not 214 ward councillors. It's 214 councillors in total. And the PR councillors are the ones in 4.2, and the ward councillors are the rest. In 4.1, yes. In fact, if you look at 4.1, Justice Majid, you'll see there the ANC won 68 out of 107 wards, and the DA won 39 out of 107 wards. So there are 107 ward councillors, 68 from the ANC and 39 from the DA. And then you get the PR councillors. So if you add the figures in 4.1 to the figures in 4.2, you get the total number of councillors, and you get the figures that I have read to you. And the missing party, when I read you that thing and I said there was another party.
Is the Freedom Front Plus?
Yes, it was just a typo on my note. Thank you.
Mr. Butlander, your order doesn't say all councillors are to stay, which means that the DA councillors are free to walk out as and when they want to. There won't be consequences, really. The court order doesn't apply to them. It is those who, without any disciplinary process of any sort, against whom the order operates. It's only the EFF and the ANC who must stay. The DA councillors can just walk out as and when they feel like it.
But Chief Justice, the reason for
as
that,
long as it's for 1 day, for instance, it's not for 3 days.
But the reason for that is that one only grants an interdict or a mandamus when there's been shown to be a breach of an obligation. So that's the reason that it wasn't sought against the others, because you can't grant an interdict or a mandamus against someone who isn't breached. But I'm going to get an instruction, because I suspect that I would be, I'll get an instruction about whether my client is agreeable to the order being made applicable to the DA as well.
Yes, I was only going to say, now that the problem has arisen, all you simply have to say as the court is all councillors. Rather than leave others untouched and isolate others without any process having been followed to determine even which of the members of the parties affected have been staying on, if any, and which of them have been leaving. How does the court know all this? Whether none of the other people ever stayed. I mean, it's almost as if the onus has now shifted to them on the basis of what you said earlier, that it was up to, say, a member of the EFF to come and say, no, I'm not one of those that have been walking out, I've been staying on. It's concerning.
Chief Justice, I've taken an instruction and there's no objection to an order being made against the DA councillors, all of the councillors, or as you deem fit. This court has the power to do so.
Mr. Butlander, the problem in council, is it because that is now in respect of those who are not attending? Is it because of their delinquency or because of the disagreement between the political parties? And the order that you seek, aren't we now compelling those political parties that do not agree with the DA to attend council meetings?
Justice Mhlantla, the order you make, the root of the problem is a disagreement between political parties. But the cause of the collapse is what has been done in respect of that disagreement. And that is the delinquency in failing to attend or remain in attendance at meetings. You are not compelling anybody to agree with the DA. You're not compelling anyone to vote for a DA mayor or to vote for a DA proposal. All you are doing is compelling councillors to adhere to their legal obligations. And when they attend the meetings, they can vote against the DA, for the DA, abstain, they can make speeches, they can do whatever they like, but they must attend. And so it's true that at the root is a political disagreement, but what this court said in Calm, and I must commend Calm to this court, is that because sometimes it's one party in power and sometimes it's another, you can't say that merely because I'm out of power, I'm unhappy and I'm not going to attend. Chief Justice, I'm anxious about time because I have kept the court. Could I deal, if I may, with the last point briefly? Which
Mr. Butlander. Yes, just before you step off, would staging a walkout or even saying, I'm not saying this in the face of a court order now. Let's say, let's posit a situation where there's no court order, or even saying, I will not attend a council meeting for as long as X situation persists. Is that expression for purposes of section 16 of the Constitution or not?
Justice Madlanga, why do you ask a freedom of expression lawyer a difficult question at the end of the hearing? I don't know whether it's expression, but there's a short answer, which is that if it is expression, it is expression that is limited by virtue of the code, which is part of national legislation, and nobody has suggested that that code is unconstitutional, because the code does not suggest that you can do it because you don't want to, or because you've got some valid conscientious objection. And nobody has suggested that that is unconstitutional, and that is part of national legislation.
But, oh gosh.
I can hear you, Justice.
We can hear you, my
Oh,
brother.
thank you. Thank you. Thank you. A follow-up question though. In accordance with the principles applicable to the rule of law, one must, amongst others, one must know beforehand what the law is. And if it is a law that has sanctions attaching to it, one must even know what those sanctions are. Now, there is provision in the code, and there is even, you know, one even knows or can tell from the four corners of it what happens to you if you have not acted in accordance with that code. Now, the worst that can happen to you is for you to be expelled from council. Now, somebody can say, I am willing to stick to or stand by my convictions, and because of X, I will always go in there, but stage a walkout, or I will never go there at all. And if we accept that perhaps that is expression, they would be exercising their right of freedom of expression. And they say, I don't care what happens to me. If in the end it means I'm expelled, so be it. But they nowhere do they foresee the possibility of them being forced against their convictions and in contravention of their Section 16 right to attend a meeting, remain in attendance. What would your response be to that?
No, with respect, Justice Madlanga, it seems to me that that's incorrect. They are forced to attend the meeting. They are forced to remain there, notwithstanding what conscientious objections they may have. That is the law, and that is the law which has not been challenged. It is true that everyone, of course, is entitled to say, notwithstanding the law, I'm going to break the law, and I'm going to face the consequences, which previously would have been a potential removal as a councillor. Now they will know going forward that if they are not to attend, they will face potential removal as a councillor, and they will face potential imprisonment for contempt if it's willful and mala fide. So with respect, with respect, I can't hear you, Justice Madlanga.
Sorry. I'm saying is that very last part that I have difficulties with, not attending on pain of possibly even going to jail, something that's not at all contemplated in the code. That's going beyond the code. One could say, yes, the code says I must go, but my convictions say for ABCD reasons, I just cannot. And Section 16 entitles me not to go. And I'm saying I'm exercising that right. The worst that can happen to me is expulsion. But I will, in the exercise of my Section 16 right, not have had to go if I do not want to go. Now, if the court says you must go and you must remain, then you may even face jail, something that is not at all contemplated in the code. I have difficulties with that.
Justice Madlanga, I understand your concern, but the truth is that freedom of expression in some circumstances has consequences, and sometimes they are serious consequences, and sometimes they are jail consequences. If I'm a nuclear protester and I climb up to the top of Koeberg in order to protest against nuclear power, I do so knowing that I will be prosecuted for trespass and I might go to jail. And I make my election on whether I wish to take that risk and how firmly I believe and all the rest. And this court is not doing it retrospectively, it's only doing it in a forward-looking fashion. And the point I would make with respect is that by compelling them to attend, if there is a limitation on freedom of expression at all, it is a minor one, because they can go and say what they like in the council meeting, protected by qualified privilege. They can go and vote.
Why, why your Kubek example doesn't work is that the person elects to do it knowing that they may be sentenced to go to jail. So they know that beforehand. So the analogy does not work at all. I don't think, at least.
But with respect, it does work, because they're not going to jail for what they've done in the past. It would only be as a consequence of this court's order going forward. So that's why I say this court is not punishing them for what happened a month ago or 2 months ago or 3 months ago. This court is saying, as a just and equitable remedy, we're going to compel you to comply with your existing legal obligations, which you accepted when you were elected as a councillor and when you decided to start getting paid as a councillor on a monthly basis. And if you decide now to breach those obligations, these are the consequences. So that's why I say I make the Kuberg point, just to make the point that freedom of expression sometimes has consequences. It's not a risk-free endeavor. Chief, unless Justice Madlanga, if that answers the question, whether or not you're satisfied, if I've answered the question, perhaps I could move on.
I think you can see, Mr. Butler, this issue exercises our minds. This is in the heart of political arena, even though the issues come up as legal issues because they flow from the Constitution and statute, but it is basically a political matter. And what worries us is this: Parliament has seen fit to oblige councillors to attend meetings and remain in attendance. It says so in the code. Now we're having a court order reinforcing the same point, that they should go and attend and remain in attendance on pain of other issues which are not within the code. That which you have just debated with Justice Madlanga, that you might even end up going to jail. Something that sits outside the code. And on the example of Justice Madlanga, one could even say, I'm prepared to stick it out until we get to the process where there would be an inquiry into my breach, and then I can deal with it then. So it is really concerning.
But Justice Jafta, with respect, that is the effect of every mandamus. It is the effect of a mandamus, every mandamus ranging from whether I continue building late at night, putting a nuisance to my neighbor, to maintenance orders, to everything else. The law, the court grants an order compelling compliance with the law. And if you then don't comply with the law, then you face the consequence. And if a councillor truly feels on a conscientious basis that they cannot live with this, then they ought to resign. But what they cannot do, with respect, and what this court cannot do, is fold its hands in the face of what the papers reveal is a deliberate obstruction and a deliberate breach of duty, and say we can't give a remedy. And let me be clear, if I may, with respect, again, we're only debating remedy. The question of the lawfulness of the MEC's decision, I've already dealt with, or the government's decision. So the court is remaining now with the question, does the court merely set aside, or does the court grant an effective remedy? And my submission is that that is what a court does. If the court, let me say, if the court can conceive of a better and more effective remedy, then I appreciate the court will consider granting such an order. But with respect, a court can't fold its hands and say, there was this decision, you do have a right to govern Shwani as previously, but I fold my hands and I decline to give you a remedy, an effective remedy. That's been clear since FOSA.
Mr. Butler, I disconnected, so I don't know how far you've gone with my brother Jafta. But here, and I don't even know whether you are done with him. Are you done, my brother?
I'm done, Chief Justice.
I don't understand something. The code doesn't seem to compel councillors to attend and remain.
No, but that must
meaning that you may attend, it's absenteeism that is sought to be addressed. You may attend, and when it comes to a particular issue, decide that now I'm leaving, for whatever reason. Now, we seem to have taken it a step further. We are not only going to say you must attend, but you must stay there. Don't move. Does the code perhaps provide for that? Stay and attend and remain? Even if it's 5 minutes left or whatever, you must stay there.
Yes, Chief Justice, it does. It deals with it under 4.1b, and it says that the council may impose a fine for failing to remain in attendance at such a meeting.
So it's attend and remain.
Yes, and that must be so with respect, because otherwise the section would serve no purpose, because you could arrive, meet the roll call, and go off and spend your councillor's salary doing whatever you liked, and the purpose would be undermined. Thank you.
Thank you.
Mr. Butlander, may I just raise something with you in response to this question of the remedy, which also bothers me tremendously. You said earlier in response to a question by one of my colleagues that the reason why you had gone this route in seeking this mandamus is because you wanted, as you put it, an immediate solution and not to have to put a matter in the hands of the MEC, where you say can't be trusted on these papers from your perspective. But where a litigant comes to court and asks a court for a particular order, which suits it for its purposes and its convenience, but for the court to make that order would seriously impinge on the separation of powers doctrine and would get the court involved in political contestation as we have here. Is it not for the court then to step back and to say, so as not to make myself guilty of judicial overreach, I'm going to go for the solution in 14.4, which is the question of the MEC intervening. On what basis should what is good for the goose not be good for the gander, where you say the MEC, the provincial government, the premier should have considered less intrusive means? On what basis should the court not step back and take less intrusive judicial reach of 14.4 of the Code of Conduct in this instance?
Justice Majid, let me say two things, if I may. The first is I readily accept that this court is empowered and required to grant an order that it considers just and equitable. And I readily accept, I think it is in Mhlope's case, that the power to grant a just and equitable order includes a power that is a remedy that was not sought by the parties concerned. If this court has said so expressly, I think it's in Mhlope, it's economic freedom fighters, but there are a lot of those, but we'll find you a reference in a minute. So I accept that this court must decide what it considers as the appropriate remedy. It's not for my client or me to decide, and this court will grant the appropriate remedy. But what I would submit is that the order has to be effective. And that, I keep mentioning FOSE, but it's clear since FOSE that in order for a just and equitable order to be granted, it must be effective. If this court is satisfied that the more appropriate order is to direct the MEC to hold an inquiry into all of this and to consider disciplining councillors and to put the MEC on very short timeframes to do so and perhaps report to the court, because that's the only way I can envisage it working, then this court will grant such an order. But the court has to grant an order that is effective. And merely referring it to the MEC in my submission and in light of the facts set out wouldn't achieve so. Yes, it's paragraph 211 of the Economic Freedom Fighters versus the Speaker, 2018, volume 2 of the South African Law Reports, which says that this court has the power to make a different order. So I accept that. I've explained why my client sought the order that it did. I've explained why a mere referral under 14.4 would plainly be inadequate. And if the court were contemplating that, I would ask the court to maintain supervisory jurisdiction, because the only way it would have any hope of success would be if the MEC was on shortened timeframes and had to file reports about what he'd done and what he'd found. And presumably that would also enable the court to see whether people actually attended the council meetings in the interim. And if needs be, perhaps that would enable us to come back for a further remedy.
Thank you.
Chief Justice, if I may, that leads me to the last point, and the last point was the one you raised with my learned friend, Mr. Ngukatobi, about the 90-day period, and I need to just say one word about it, if I may. Chief Justice, the dissolution decision was made on the 4th of March. It came into force on the 18th of March, so it was with effect from the 18th of March that the councillors left office, and Tshwane became governed by an executive-appointed administrator, appointed by the province, rather than the people elected by the city. On the 29th of April, the High Court set aside the dissolution decision, and subject to a debate about COVID regs, because we were worried about lockdown, that order would have come into force in early May 2020. But of course, there was then the appeal to this court, which suspended the operation of the order. So my clients brought a Section 18(3) application under the Superior Courts Act, seeking interim execution pending appeal. The full court heard that very rapidly, and on the 10th of June, the full court granted a Section 18(3) order. So it said, notwithstanding the application for leave to appeal, the order should be in place, and it relied very heavily on the fact that the 90-day period for an administrator had come and gone. But, and this is the last piece of the puzzle, Section 18(4) of the Superior Courts Act says that a party losing an 18(3) has a right of automatic appeal to the next highest court, and that when that happens, the execution order is suspended. So the EFF and the government, not the ANC as I recall it, not the ANC, appealed to the SCA. And although my clients made every effort to get the matter heard as one of extreme urgency, which is what Section 18(4) says, it says in words, those words of one syllable, an appeal like that must be heard as a matter of extreme urgency. The appeal was ultimately only heard on the 17th of August, and it is still pending, some almost 4 weeks later. So we are in a world where, I give you that history for the following reason. What this means is that the dissolution decision, which we contend is unlawful, has resulted in a lack of democratic government in Tshwane from the 18th of March until today. That is 176 days by our count. In 4 days' time, it will be 180 days, which is double the 90-day period envisaged in Section 159(2) of the Constitution. Now, I'm not blaming the administrator for it. It's not his fault. I'm not blaming the MEC for it. It's not his fault. I accept that it is partly a consequence of COVID and the electoral court order, which extended all electoral court, or all elections. But the practical reality, Chief Justice, is that as things stand, the councillors in Tshwane are out of office. They are not receiving salaries and haven't for many months. There's no democratic government in Tshwane, and that is all a consequence of what we say, and we hope the court is persuaded, is an unlawful decision, and that's more than double the 90 days. We say that in those unusual circumstances, if the court were in a position to rapidly grant an order, to either grant an urgent judgment and order, or to grant an order with reasons to follow, I don't mean today, of course, but in the next week or so, we would commend that approach to the court. And we would simply note that the court has done so previously in at least 2 cases where it's granted such a substantive order without reasons. It did so in SA Informal Traders versus the City of Johannesburg, 2014, volume 4 of the South African Law Reports, page 371. And it did so in SASA versus Minister of Social Development, 2018, volume 10 of the Butterworth's Constitutional Law Reports, page 1291. It's a decision of this court. Chief Justice, I make this request respectfully and fully mindful of the constraints on the court, and I make it fully mindful of the fact that it will depend when this court adjourns, whether it is unanimous or not unanimous, or how convinced it is. I leave it in the court's hands, but it does seem to me with great respect that there is, there is plainly a real urgency and a real problem. We would ask the court to consider this route.
Mr. Badlander, would that not impact the pending appeal in the Supreme Court of Appeal?
It would render it moot, Justice Chiki, because that appeal in the SCA was only to govern the interim period until this court is pronounced. And the theory, of course, is that the 18(3) and 18(4) process should happen long before this court has even dealt with the matter. If this court is able to deal with the merits of the matter, quite frankly, one way or the other, quickly, it would be advantageous. because if this court finds that we're right, then it should set aside the decision as soon as possible, and the SCA then doesn't have to worry about the interim relief. Or if this court finds we're not right, and the dissolution decision was lawful, then again, the SCA shouldn't have to make an interim order. And so it would render that matter moot. But we submit that's perfectly appropriate because this court has now had the benefit of full argument on the merits. And if it's in a position to give an order on the merits, that would be appropriate. Chief Justice, those are our submissions. It remains only to deal with the question of costs. We submit that this is a BioWatch case. If we are successful, we submit we're entitled to our costs. If we're unsuccessful, there should be no order as to costs because it's the pursuit of a challenge to the lawfulness of state conduct, and BioWatch operates. Chief Justice, this has been a novel case brought extremely urgently throughout, and we therefore asked for the costs of 3 counsel. I think my learned friends may have done likewise, and I would ask for that again. But we leave that in the hands of the court. I appreciate it.
Mr. Badlender, excuse me.
Yes, Justice Matopo.
I want to take you back to the order of the proposed or the contemplated order of the SCA, which my sister Chick asked. If the appellants or the applicants before the SCA are unsuccessful,
Yes,
that would mean the order of the High Court must be put into operation. Am I right?
correct. That is correct.
And that order would mean the order as we see it before us.
That is correct.
Then does that mean that there would be a need for this court's judgment to be expedited?
It depends on what this court thinks of that order. Because could I just explain why? If this court is broadly comfortable with the order of the High Court, then with respect, there's no, and if the SCA appealed and the 18.4 is dismissed, then there's no need for expedition because the SCA order will govern the interim period until this court pronounces and everything will be fine. But of course, and that will include the reviewing and setting aside of the dissolution decision and the mandamus. But if, of course, this court is concerned about the mandamus and wishes to impose a different remedy and thinks that the mandamus may be a problem, then that would be a reason for this court to give an order as soon as possible to limit the effect of the SCA order and to put in place the proper remedy. But of course, as things stand, I don't know what the SCA order will be. So it's also possible that the SCA could uphold the appeal and then my clients are left remediless unless and until this court is pronounced on the merits. So either way, there does seem to be a need for expedition in my respectful submission.
Let me try and process this thing out. If the SCA finds against the applicants, then the order of the High Court must remain.
Yes.
And then if this court, and if the order of the High Court remains, it means the dissolution must be set aside and people must go back. But then you'd still have the issue relating to the mandamus.
Yes.
And if this court then were to agree or accede to the appeal, that would mean that the administrator would have been set aside, and when this court's order is granted, if it's against the DA, it means the administrator would have to come back.
Yes, yes. And can I make, I'm not trying to make matters worse, but might I? What's worse is that under the dissolution decision, if it is not set aside, elections had to be held within 90 days. That got extended because of COVID. The present electoral court order requires elections to be held Tshwane-wide before the end of December. So if the SCA, let me assume the SCA dismisses the, let me assume the SCA upholds the 18.4 appeal. That means that the High Court order remains suspended and that as things stand, there will have to be an election Tshwane-wide before the end of December, and the IEC will have to start organizing that election immediately, I would have thought. And yet, of course, if this court finds on the 15th of December that the dissolution decision was invalid, then the election shouldn't happen. And if this court finds in January or February next year that the dissolution decision was invalid, then the election itself was invalid, and the election results were invalid, and the money was ill-poorly spent. So when I ask for an expedited order, if possible, I make it in the interests of all parties, and I ask for it irrespective of what that order is, because certainty is actually required. And with respect, that is irrespective of whether the SCA rules in my client's favor or against me, because this is just not a matter that can wait months and months for the reasons I've articulated. Thank you. Chief Justice, unless there's anything else, those are our submissions. I'm just looking, I think those are our submissions.
Thank you, Mr. Butland. I keep on disconnecting. I try to switch off the video, hoping that the disconnection would be lessened. It looks like it's a bit of a challenge. Thank you very much.
Thank you.
Mr. Ngugaitobi?
Thank you, Chief Justice. I wonder if I may, I initially promised 10 minutes, but I wonder if I may be permitted an extra 5.
No, it is well. It is well, Mr. Ngugaitobi.
Thank you, Chief Justice.
Thank
Can
you.
I start with I think most of the time was spent on the issue of the mandamus. Maybe let me start there before I go to the merits. There are 5 reasons why the mandamus is inappropriate. We set out 3 of them in our heads of argument. The first reason is that it potentially violates freedom of expression, not just expression, but also the right to protest. And the right to protest entails the right to walk out of meetings. And so because of the impact that it has on expression rights and the rights to protest, it is not just and equitable. The second reason, which we also set out in our heads of argument, is that it breaches separation of powers. The reason it breaches separation of powers is that it takes over the function of disciplining councillors, which belongs in the first place to the council itself, and in the second place, which belong to the MEC. But it usurps those functions in effect because it superimposes a regime of contempt of court. And so it's in breach of separation of powers. The third reason why we say this is inappropriate is that the code contains a mechanism for dealing with its own breaches. That mechanism includes investigations, disciplinary actions, and potential appeals to the MEC. And the code effectively overrides those internal mechanisms. There is a principle usually adopted in the labor cases, which this court has adopted, which states that where a law contains a mechanism for dealing with its own breaches, that mechanism should be followed. This is precisely where we are. The fourth reason is a reason of practicality. Mr. Badlander had to explain how they hope to elect a mayor on the basis that although the parties may attend, they are entitled to withhold their votes. He ultimately stated, using the comparison of the national elections, that those people who are present, regardless of their numbers, can vote. The problem is that he forgets that the council has a determined number and it functions on the majoritarianism principle. So you need the presence and the participation in the vote for the mayor to have any legitimacy of election. The other reason why it is not practical is in relation to certain specific decisions. Take Section 30 of the Municipal Structures Act and take Section 160 of the Constitution. decisions about the passing of budgets and the decisions about the passing of bylaws, which are in the heartland of local government. Those decisions cannot be taken by mere presence. They can only be taken by presence and voting. And the order does not allow or does not require a voting, nor can it actually require a voting as such. And so it is in fact an impractical order because it takes us back to where we started. One of the grounds of dissolution that are permitted in the law is where a municipality fails to pass a budget. And if we have a scenario where a council sits, it cannot pass a budget, it would be liable to a dissolution by the MEC, which means we go back precisely to where we started. And the final reason why this is an inappropriate order is contained in the code itself. The order says you must attend and remain in attendance. Of course, the only obligation is in item 3. It is the obligation to attend. Item 4, which is what Mr. Butlander read, is not the obligation to attend. It's the sanctions. It's the imposition of sanctions for non-attendance of meetings. And that is what the sanction is. It's not an imposition of the obligation to attend and remain. And so the order itself is incongruent or inconsistent with the terms of the code of conduct. And so for those 5 reasons, it was an inappropriate order, neither just nor equitable. But Chief Justice, this particular part—
maybe before you move on, Mr. Nkaitobi, is the right to protest based on Section 17 of the Constitution? That you alluded to.
Yes, it is. Section 16, Section 17, and Section 19.
Well, 17 and 19.
16, 17, and 19. So those are the rights that are affected.
Well, let's focus on protest. Would protest be located in 17 only or both?
Sorry, Chief Justice, I'm just looking for my—
Because I'm asking because 17 reads, everyone has the right peacefully and unarmed to assemble, to demonstrate, to picket,
yes, and
to present petitions.
Yes, yes.
Would
So
it apply to a councillor?
Yes, indeed.
Would it apply to a judicial officer, for instance, saying I'm protesting now and walk out of court and so on? Isn't it for certain situations, not that particular one? Or am I limiting it unduly?
Chief Justice, you are limiting it unduly. That right, particularly the expression right, has been held by this court to also apply in relation to members of parliament.
Expression or protest?
Expression, Section 16.
Expression is a different one. I was focusing only on protest.
Oh yes, I understand, Chief Justice. What I argue about protest is that these councillors also have the right to protest, which may include in certain instances a right to walk out in protest of a political decision they do not agree with.
And as long as they under 19, it wouldn't. That would be under 19 rather than 17.
Chief Justice, you are right. It would be under 19(1).
Yes.
B. Indeed, that's correct. Thank you, Chief Justice. So those are the 5 reasons why we say this is an inappropriate order. But Chief Justice, not only is the order inappropriate as a question of remedy, the reason why this is so crucial for this case is because this was regarded by the DA as the only mechanism to ensure the fulfillment of the executive obligations. This was the less restrictive mechanism. And this is what was adopted by the court as the less restrictive mechanism. So it's not only about remedy, it also is about the less restrictive means that are contemplated in Section 139(1)(c). So if the phraseology, whether it is less restrictive or alternative means, the reason why this was ordered was because the MEC was found to have acted unconstitutionally on the merits because he did not impose the disciplinary regime that is contained in this, and that is why it was granted. And so the consequences of a finding that this is an inappropriate mandamus go to the merits of the case. They go to answering the question whether there was in fact any realistic alternative to dealing with the situation. The DA offered one. Today, Mr. Badlander spent an hour unable to offer another one. The High Court also offered this particular remedy and no other remedy. But the reason this was ordered was because it was perceived as the only mechanism to break the deadlock in order to ensure that the objects behind Section 139(1) are fulfilled. Once it has been found to be inappropriate, what it means is that we are left precisely where we started, which was in the context, and this is why the question by, I think it was Justice Chico, who said, I can understand your protest about water, that water could be fixed. I can understand your protest about electricity, that it could be fixed. What was unfixable was the political paralysis. And so this takes us back, Chief Justice, to where the discussion ended. How could you fix the political paralysis, which has its roots in the mistrust between the EFF and the DA? And let's face it, since 2016, Chief Justice, the DA and the EFF worked perfectly fine. Their meetings were correct. What happened is that there was a change of political positioning between the EFF and the DA. And that is why the EFF started taking a hostile stance towards the DA. If that cannot be cured juridically, it is a political question that can only be cured politically. And so that is why this is not just a question of remedy. It is a question of answering the so-called less invasive means. It simply shows to the court there are, in fact, no less invasive means. There is, in fact, no alternative. A dissolution is the only appropriate solution to the political crisis at hand. That takes me then to the third point, Chief Justice, which is the question of process. Mr. Badlander spoke at length about trying to get this process issue back to the agenda. You see, Chief Justice, the High Court, I already showed the passage in the High Court judgment where the High Court specifically said, we are not going to deal with procedural fairness at all, period, full stop. We then wrote an application for leave to appeal in which one of the issues we complain about is procedural fairness. The DA responded at page 876 at paragraph 15.2, where they say, moreover, the Gauteng government addresses vast swaths of its affidavit to the issue of procedural fairness stroke rationality. Procedural fairness or rationality. That's the criticism why they are saying we are misleading the court, we are being inaccurate. And they say, but the full court's judgment was not based on procedural fairness at all. It expressly declined to decide that issue. Nowhere in its answering affidavit did the DA ever go back to the issue of procedural rationality. The issue emerges it emerges in their heads of argument, but it was inappropriate to resuscitate the issue of procedural rationality, bearing in mind the High Court's decision and bearing in mind the pleaded case of the DA to this court. And that is why it's inappropriate for Mr. Badlander to now seek effectively to take over the discussion and then to profit from it, because his own client's pleadings criticized us for resuscitating the issue on the grounds that that issue had been put to bed by the decision of the High Court. But Chief Justice, moreover, Mr. Badlander spent a lot of time reading from affidavits, and his reading is actually quite selective. If you look at what the attack on procedural fairness was in the High Court, the DA never complained that they were not given Audi in relation to the dissolution. They did not say you did not give us notice that you intend taking a dissolution under 139(1)(c). It is at page 525, and I would really ask the court to go through the pleaded case of the DA on procedural fairness to show why it's actually quite inappropriate what Mr. Badlander has done. I know we want to win cases, but we must win cases properly. If you look at page 525 of the founding affidavit, where they address the issue of procedural, it says first review ground, procedural fairness, and sorry, that's the replying affidavit. What I actually wanted is the founding affidavit. It's page 31. Sorry, Chief Justice. It's page 31. That's where they make out their case on procedural fairness. from paragraph 88, 89, 90, 91, 92, and then 93, they set out their case. I submit that a fair and rational process would have entailed at a minimum, and they set out, issue the municipal council with a written notice identifying the executive obligation. After identifying the obligation, issue a directive. Number 3, invite the council to submit representations on why they failed to fulfill the identified obligation. Number 4, allow the municipal council reasonable time to submit representations and to perform the identified executive obligations. Number 5, give proper consideration with an open mind to the representations of the municipal council and councillors and tailor its intervention narrowly in accordance with its assessment of the representation. Paragraph 94, the Gauteng EC did not comply with the above procedural requirements. And then it says, accordingly, the Gauteng EC failed entirely to comply with the principles of procedural fairness and procedural irrationality. Nowhere in these 2 pages, 3 pages rather, where they attack the decision, do they say our gripe is that the notice, the final notice, did not contain the provision that we intend dissolving you, give us representations. That is not the case that was made. This is why, Chief Justice, the answering affidavit, and I read it at the beginning, explains in relation to the pleaded case, all of the steps that were taken from the 6th of December to the 4th of March 2020. They explain the first notice of the 6th of December, the second notice of the 14th of January, the third notice of the 4th of February, in order to dispel the idea that these minimum requirements that are spelled out by the DA at page 33, paragraph 93, have no factual foundation. Even in their replying affidavit, Chief Justice, at page 525, they address the issue of the procedural irrationality as such. The procedural irrationality from page 525 to 531, they criticize the explanation that we have given, but they still do not bring themselves to the case that they are now advancing before you, which they have advanced in the heads of argument, which is our gripe is a narrow gripe. It is once you had decided that you are going to dissolve us, we are entitled to audit on that dissolution. Their gripe is still similar to the gripe that is outlined at paragraph 93. In any event, in a replying affidavit, they were never entitled to make out a new case. Their case had to be made in the founding affidavit. So the pleaded case, the procedural unfairness stroke irrationality in the pleaded case was fully addressed by the MEC. And the attempt at, Mr. Badlander says, I've shifted arguments. The person who has shifted arguments from what his client has pleaded is himself. So the attempt to shift the argument from the pleaded case into a narrow case about you did not give me notice of the intention to dissolve, it's not the case that they said was a problem in the founding affidavit. So that's the answer to the so-called procedural fairness argument. And the third problem with it, if you look at procedural irrationality that they are protesting, it is part and parcel of the broader rationality inquiry. It is still about ends versus means. Who would have had to be consulted in order to make the decision under 139(1)? It is the council. That's the council that would have had to be consulted on their own version. But for what end? The end is clear under 139(1)(c). The end is the assurance of the fulfillment of the executive obligations. What facts did we know? We knew the facts. There had been 10 meetings that had collapsed, they had not correlated. From the point of view of the MEC or the point of view of the provincial government, there is clearly a collapse in Tshwane. They are blaming each other about who is to blame. The ANC blames the DA blames the EFF blames the DA. But from the point of view of the MEC, who is sitting outside, not as a participant, but as an outsider, what he can see is that there is a dissolution and a mistrust and a chronic failure of service delivery. So from his point of view, it was perfectly rational to dissolve the council because it cannot function. And those were the findings made in the High Court as well, that the council could not function for reasons that were unrelated to the conduct of the MEC. I hear today that the DA does not trust the MEC, but they want to be reinstated, but they have to work with this MEC. And at the same time, their main argument is cooperative governance. But at the same time, they say that the the MEC is to be distrusted. So in relation to the issue of procedural irrationality, the object was always to ensure the fulfillment of executive obligations. The facts were known to the MEC, and the MEC acted in accordance with the facts that were before him at the time. So that answers in full the question of procedure, which the correct thing to do with the procedural issue is simply not to decide it because of what the High Court did. Otherwise, one places the MEC in a great disadvantage of having the issue essentially raised for the first time, debated for the first time during the course of the oral argument. Mr. Butlender's criticism that we decided not to deal with procedural fairness have absolutely no foundation. Anyone who read their answering affidavit fairly and objectively would have come to the conclusion that this is not an issue that arises, because you would have had to read that in the light of the findings by the High Court. Then, Chief Justice, if I can spend the last remaining minutes of my time just addressing issues of broad principle. One of the issues that seem to underlie the argument of the DA is the idea that there is municipal autonomy and municipal independence. And because a Section 139 procedure is an invasive procedure, it should therefore be restrictively construed. But of course, the problem with the argument is that it overlooks the other interlocking provisions of the Constitution. The Constitution is not designed to create an island of independence called municipalities. The Constitution creates a single government comprising of 3 levels. National government may intervene in provincial affairs under Section 100. Province can intervene in local government affairs under Section 139. And the reason why it's necessary to keep a balanced view is because a counter to the provisions like Section 41 and Section 151 and Section 153 is Section 152 and 153, which makes it clear that the purpose of the existence of local government under the Constitution is service delivery. And Section 139 is a mechanism to balance democratic accountability and a collapse in service delivery. So one cannot interpret the Constitution in a way that emphasizes one section at the expense of another. What one needs is a balance between the constitutional requirement for service delivery and the other requirement for democratic accountability. Interestingly, Chief Justice, in this case, both objects of local government, democratic accountability and service delivery, had collapsed. The democratic accountability had collapsed because the elected officials were not attending meetings. So they cannot now trumpet democratic accountability in the light of the fact that that too had collapsed. And the purpose of the intervention, if one looks at Section 139, is not to punish anyone. The purpose of the intervention is to vindicate the interests of consumers to service delivery. That purpose is expressed twice in the Ngagamodiri case, in paragraph 13 and paragraph 14 of the Ngagamodiri judgment of this case. That is the underlying purpose of the Section 139, is the vindication of the consumer's rights to service delivery. So when the municipality collapses, an intervention is warranted. Here, Chief Justice, and one can forget about the other additional grounds that we outlined, the other 9 grounds. Here, Chief Justice, take the 2 that are common cause, or maybe 4 that are common cause. The collapse, absence of mayor, absence of municipal manager, absence of mayoral council. And take the crisis of water, take the crisis of Wonderboom. These are common cause facts. Mr. Butler spent 30 minutes trying to show that a document that they prepared was not given proper consideration. What he overlooked was that the High Court itself accepted on the facts that the objective reality was that the DA and the EFF had collapsed service delivery. So at the end of the day, we are asking for a balanced approach to constitutional interpretation. The structure of the Constitution must be understood to create the balance between democratic accountability on the one side and service delivery on the other. Where it collapses, Section 139 is a mechanism that should not be undermined, because we have a crisis in this country, which everybody knows about, of local government that is dysfunctional. And the instrument in the hands of provincial government is a dissolution instrument. Then Chief Justice, I've answered this, I've answered that, I've answered that.
Mr. Guy, tell me,
Yes,
are you saying then the only solution was Section 139?
Absolutely. On these facts, Justice Teron, this is a most extraordinary scenario, what we had in this case. On these facts, the only solution was a Section 139 intervention. And by the way, Justice Teron, even the High Court did not find that the intervention itself was unwarranted. Even the DA does not argue that the intervention was unwarranted. What this debate has been about has been a debate about the mechanism chosen to intervene. So at baseline, Section 139 was the only available tool. You could not get these people to work together. And there is a criticism, Justice Teron, just to finish up on this point. There is a criticism that is, the DA sometimes raises it, and then Mr. Badlander sometimes embellishes on it, which is that the ANC is in charge in the province. And in the municipality, the ANC disagreed with the DA. And somehow this was an attempt at getting back at the DA. Now, the problem with that is a legal problem. The ANC is not the same as the provincial government. Just like the councillors of the ANC are not the same as the ANC itself. And that distinction is drawn, made clear in the judgment of Malema versus NCOP by the Supreme Court of Appeal. The mere fact that the MEC happens to have been seconded by the ANC does not mean when he acts qua party comrade. He's acting qua official as MEC. So if you took yourself back from the scenario and you were the MEC, you are watching not a collapse that was overnight, but a gradual collapse, where when you ask them for explanations, they blame each other. The only remedy you have under the law is a Section 139 intervention, which no one denies. So it's not even a question of it being appropriate. It was, in fact, the most appropriate thing to do. Yes, the one thing I just need to clarify, Mr. Badlander was, he supposedly took the court to the version of the province, and his constant refrain was bad denial. The problem, of course, is that he did not take the court to the initial parts where the full explanation is given, which starts with 364, and I don't want to take the court through it because it's the chronology of relevant developments, which sets out the full chronology. And it answers both questions. It answers the question of what else did you consider before you intervened? And it also answered the question as to what were the substantive reasons for the intervention. And they explain from 365, paragraph 24, the provincial executive first sought to directly intervene when it issued the notice in terms of Section 139(1)(a) of the Constitution. So the idea, and he kept making the point that you will find no explanation in the answering affidavit about what other mechanisms they took into account before they intervened, and yet they are expressly pleaded. And so that goes on and on and on and on and on, including the explanation as to why the provincial government rejected the representations that were made by the speaker contained in the so-called 200-page explanation, because that too is pleaded. What the province says at page 367, at paragraph 28, it says the so-called response was not a decision of the City of Tshwane Council. It was never tabled or debated at council, which on its own is a serious breach of an executive obligation. The response did not engage meaningfully with the concerns of the provincial executive, rather to rebut the concerns of the provincial executive. The City of Tshwane ought to have complied with the directives, and if there were concerns, they ought to have challenged them. None of this occurred. Instead, and quite frankly, more startling is that the response from Councillor Matebe was on behalf of the principal stakeholders in the city of Tshwane, who to this very day are unclear. So it was explained why that purported explanation was rejected as inadequate, because it had no mandate from the council itself. And also it did not deny the underlying facts. All it did was to admit the facts and then to say, we are fixing them. But that is admitting the facts and then offering an excuse for what you are doing. Even in relation to the question of Hammanskraal, they admitted the water crisis and then they said we are fixing it. Wonderboom, they admitted the Wonderboom crisis and then they said we were fixing it. The problem of the political paralysis was simply undeniable. So in relation to each of, and including the question of the failure to spend the grants, they admitted that fact, that they were not spending the grants. Their case was that there is no obligation to spend the grants. So what we have is, you've got a long document, of course, but a close analysis of that long document shows that the underlying facts were common cause. Even the question of irregular expenditure, fruitless expenditure, unauthorized expenditure, that is an objective fact that comes from the Auditor General's report. There is nothing they could have done to deny it. They admitted it, and then they sought to explain it. Even the question that they had failed to recover the funds that were wasted, they admitted it, and then they sought to explain it away. So there is, in fact, no proper explanation that was given for the underlying facts that were set out in the notice of dissolution. So we would say, with the greatest of respect, that if we go back to the baseline requirements of Section 139, we had unfulfilled executive obligations. They are established on the facts. The DA's case primarily rests on the fact that they are fixing those problems, but that is not the same as saying the problems do not exist. Secondly, we have an intervention which on the facts was the most appropriate, the only appropriate, or the appropriate situation. Thirdly, we have exceptionality because we have a confluence of the collapse of political leadership happening at the same time. And then fourthly, the clearest illustration why this intervention was warranted is the fact that the only way on the DA's version it could be resolved is the mandamus, which mandamus itself is an inappropriate mandamus. So the reality is that the appeal should be granted. The DA's application should have been dismissed because this was the only instrument that was available in the hands of the provincial government to fix the chronic collapse of the municipality. The only thing that remains on costs, Mr. Balena is right, the Biowatch principle applies. We disagree with him that they're entitled to the cost of 3 council. If they are successful, they're entitled only to the cost of 2 council. There is then the question of what we should do about the pending appeal before the SCA. There are two primary concerns.
Maybe before you go there, although you don't represent the EFF, I suppose the issue of cost does not apply to EFF. If EFF succeeds, then Mr. Bartlender would only be excused from paying the MEC's costs, but those of the EFF you'll have to pay.
Yes, those are 2 private parties. They must pay the EFF's costs.
Sure.
The only question is whether it's joint and several, because there are also individuals there.
Sure.
Bearing in mind that they have not been receiving salary, it might be neither just nor equitable to mark them with costs. The only question that remains then is what to do about the pending appeal under Section 18.4. There are 2 concerns about this issue. The one is that a question of judicial committee. It's not appropriate for us to come to this court to complain about the SCA. That's just not appropriate. The SCA is autonomous in its sphere and it is doing what it can. The fact that it has delayed, it's not now open for us to come and say and report the SCA's delays to this court. So there's a real concern about judicial autonomy, which we would like to preserve. But then there is the question of the interest of justice. We brought this appeal on an urgent basis ourselves. The DA had brought its own application on an urgent basis. And it seems that there is some interest of justice concern that an expedited outcome is warranted either way on both parties. But assessing that, one should not factor in what the SCA is doing. One must leave that space alone. Whether the SCA delivers its judgment, dismissing or upholding, should really be irrelevant. I mean, on the 18.3, should really be irrelevant to what this court does. This court is not concerned with the section 18.3. And one of the reasons why it should not be concerned about it is that there may well be an appeal against the section 18.4 order of the SCA to this court. And in that event, what does one do having made an expression on an issue that is not even before the court? And so that's why I try to suggest that just as a matter of judicial comity, I'm not saying there will be an appeal because the act seems to be to place the SCA at the apex of those applications, but who knows? So what should happen then? It seems to us that an appropriate thing is that whenever this court feels it's confident about its order, if it wishes to give an order, we are thankful for our side that our application in this court has been held on a relatively expedited basis. We only launched these proceedings in May. In March. We already have a hearing, which on its own is something unusual. So we should be thankful of the fact that we've been accommodated. And when the Chief Justice and the justices have considered the matter, they should give a reasoned judgment. What's crucial is to do justice to the parties, but what's inappropriate is to rush the court and to place unreasonable time burdens on the court. So it's in our interest to get an expedited outcome, but I'm extremely reluctant to join Mr. Badlander's suggestion, which effectively amounts to rushing the court to an outcome. Thank you, Chief Justice.
Thank you, Mr. Mugaitobi. Mr. Semenya.
Thank you, Chief Justice and Justices. Perhaps the first point requires no greater time because I read Mr. Badlander to publicly concede that the locus standi of EFF before this court is not seriously challenged. That takes me to the second point, which relates to the reading of section 139(1)(c). You would remember that Mr. Badlander is positing that C introduces two separate requirements. The one being there must be exceptional circumstances, and the other one must be, it must be warranted. But that's simply not true. Let's look at the grammar of that language. You will see that warranted is an adverb. It qualifies the dissolution. That's all that it does. It does not introduce an independent, separate burden or requirement. I'm going to read it for completeness. It says, when the intervention is taken, the intervention must be one appropriate, including dissolving the municipal council and appointing an administrator until a newly elected municipal council has been declared elected. If exceptional circumstances warrant such a step, it's a dissolution that is being qualified. It is not introducing any different matter. It's an adverb, that warranting. How can an adverb be introducing anything because an adverb qualifies an adjective or a verb? So that's not a good point to suggest that warranting is introducing anything. English grammar explains it to us. It's an adverb. Now, let us look at the analogy that he makes. He says you can't use a sledgehammer to crack a nut. Now, if you describe what is happening in Tshwane as a nut, then I don't know what a sledgehammer should be used for. Because there is one factual finding which the High Court makes with which they do not take issue. And I go back to it. The High Court makes a factual finding which I would suggest to the court it cannot be changed because it's identified in the judgment as a common cause fact. And it doesn't look like the DA is trying to upset it and challenge it. This is what it reads under paragraph 7. Simply put, it is unable to conduct its business and cannot serve its residents. It's a determinate factual finding that is made about this. Why do we go and explore whether they can provide water or whether they can do this or whether they can do the other? The court has already spoken on that point. This municipality cannot conduct its business, whatever that business is, and it cannot serve its residents. And that is its executive obligation under 139 and the Constitution and legislation. So I don't find the exercise any meaningful if it is not going to disturb that factual finding. And if you accept that factual finding, so we say, you don't need to find another one that says the weapon must be a justification. Can I go to the question of procedural rationality? And can I go and address typically an Albut situation and typically a Simelane situation? What the court there was saying, and I was answering Justice Jafta, what the court there is saying is you are impossible in law to achieve a rational outcome without taking into consideration relevant information. That's what those two judgments are talking about. They are not, an Audi is not that. An Audi is a right, a procedural right ante, before you make the decision. That's an Audi requirement. It is not in the Albut and it is not in the Simelane thing and similar judgments. The similar judgments are simply put to say, you are incapable of a rational decision outcome unless you have that information. So Mr. Badlander, if he wants to come in the Albut sense, he must say it is impossible to achieve the objects of fulfillment of the executive functions without a representation, and he can't sponsor that reasoning. You are still able in this one to deliver a rational, a lawful, legal solution by comparing the means to the end. I move away from that because I have defined Albut, I have defined the procedural rationality thing, that it is completely different to whether or not here a rational outcome is not competent. Let me now deal with the question of, I think Mr. Ngugaitobi touched on it. The problem with mandamus is by court order, you are extending and broadening the ambit of a sanction associated with misconduct. Now, that is complete infringement of the rule of law, which tells about separation of powers. It is not a question of whether you have discussed it with whoever, or whether it is fair, or whether it is just constitutionally incompetent to drive the line beyond that which the Constitution authorizes each arm of government to do. It's a separation of powers complaint. It is nothing else. And as we say, apart from the question that you abridge the processes by which delinquency must be done, you now include another sanction outside the permit that the legislature has given in the Code of Conduct. Section 41 again. If the DS argument is good, does it say the duty to consult must be initiated by the province? And if the province is not initiating it, then the consultation 41 is bad? No, 41 places the duty on both the organs that are at play. So if they thought it wanting that they must invoke 41, they should write to the MEC and say, no. We are wanting to discharge our own obligation in terms of 41, and we are seeking a consultation.
Well, it may be a problematic argument, Mr. Semenya, if you don't know that 139(1)(c) is going to be invoked. You can't seek to consult about it out of ignorance, but at least if you get informed, and but there is no indication that any representation is sought from you, then maybe you have a point that may be open to you to say, wait a minute, I've got some inputs to make.
I lost you there, Chief Justice. I lost you there.
Justice Kampepe, I do believe the Chief Justice has briefly lost connectivity.
Mm-hmm. What else do you want us to deal with?
Semenya?
Justice Kampepe, yes?
Yes, you may proceed with your argument.
Thank you so very much. Now, Chief Justice, if I understood the question, is that somebody ought to know that there is a pending 139(1)(c) before you can even then make the representation. I'm making the point, which is a different point, that firstly, that requirement is not there. But secondly, if somebody is contemplating an intervention, you must know that intervention includes C. I can't see how you cannot know the totality of a power of intervention within the section of 139. And you must be reminded that now we are going to take 139A only, 139B next, 139 at whatever point. It was within their province, if they thought that was fitting, to know that all the provisions of 139 are open because the province wants to intervene. And the point we finalize with, apart from costs, it's really that where we started. It is 139 business to look at the conduct of the municipality and not the delinquency of its members. Because the delinquency of its members and their truancy is a matter that gets handled by the code of conduct. But the delinquency or inability to discharge your executive functions under the constitution and legislation is that of the municipality. And I'm saying under the factual finding made by the court, which the court describes as common cause, (139)(1)(c) is indicated, and it is indicated as a warranted dissolution to resolve that problem. And I did not hear any debate, Chief Justice, relating to the cost issue, that if the appeal is successful, we're entitled to a cost. Oh yes, and finally, I'm reminded to say in relation to our presence today, that there is no notice to abide the judgment of the High Court at all in the record. So,
Are you there, Mr. Semenya?
I've just consulted on the last point. I'm pointed to volume 1, and I'm appointed at page 33 and paragraph 93, where the case that is made is that I submit that a fair and rational process would have entailed at a minimum that the Gauteng EC does 5 things. None of those have anything to do with giving us a notice. Those are all the submissions we have in reply.
Thank you,
Just-
Mr. Senior.
Justice Kampepe, I do apologize, but my learned friend suggested that I had misled the court on the procedural fairness issue. Could I just give the court a reference to the papers without argument and without reading it to demonstrate that that's not so? I do apologize. I know it's been a long day.
Yes, you may do so, Mr. Bartlander.
Thank you, Justice Kampepe. On the procedural fairness point, if you would just read in the founding affidavit, volume 1, page 32, paragraph 89, the answer, which is volume 5, page 432, paragraph 184, and in the replying affidavit, volume 6, page 525, paragraph 10. Thank you very much. I'm indebted, Justice Kampepe.
Thank you to counsel for their submissions. Judgment is reserved and the court is adjourned.
Today's proceedings have concluded. The host will now terminate the meeting.